What's up, everyone? Welcome back to some more Epstein narrations. Yep, I'm your host, Net Narrator, as you should damn well know by now. And we're going to get into it pretty quickly. But first of all, I fully intend for any proceeds gained from this content and my other Epstein coverage to go to Speak Out, Act, Reclaim, SAW, founded by Virginia Guthrie, who is now unfortunately deceased. And while the organisation is not currently accepting donations and I was unable to set up any official fundraiser via YouTube, I will donate the proceedings when possible, or to a similar organisation if it turns out I'll be unable to do that. And proof of this will be released when I do so. Again, I say that every single stream, but yeah, this is all done for charity. Partly to get all of this out in audiobook form, but also for charity as well. So hopefully we can, hopefully our contribution can help bring the perpetrators to justice and help those future victims of trafficking, and helping them as well. Anyway, we are in dataset 10. No, not dataset 10, I wish. Dataset 7, I should say. And most of this is a single interview. There's a bit more as well, apart from this. Interviewing a former director or a former director of justice in the state of Florida, and he had a lot of people working in their department. I think the district attorney or something like that, or the state attorney at the time where the Epstein's initial prosecution happened, where he only ended up serving 1.5 years at the time for what he did. Which, I mean, the interviewers here, I mean, they're interviewing him from the perspective of that being a travesty of justice, which I fully agree with. So, this is very interesting. We're finding out a lot of information from this. And as I say, this might not be done in this stream. It certainly wasn't done last stream. But once this is done, I'll probably clip it. I'll edit it. I'll get rid of all the, the preamble and everything. And I will release it as a clip. Because I think this is a very, very interesting looking into why Epstein was not punished to the degree that arguably he should have been at the time. Although this was in 2000. This was the investigation that lasted 2005 to 2006, I believe, because Epstein was, I think, arrested, convicted in 2007. He, at the very least, he was in prison for 2007 to part of 2008. It was originally 2 years. I think he only served 1.5. I think the official story is he gave information, and that's why he was able to get a much lesser sentence than he probably should have. But I guess we'll see, because that information is being unraveled here. Anyway, I'll start from the answering thing. So instead of saying Q&A, I put on different voices to differentiate the two people. The answerer, as far as I'm aware, is a male. The questioner is a female. So it kind of works out the way I've been doing it before. Anyway, I'll start from line 2 here, because that's where we were last time. I can't speak to the timeline. I would have, and I'm contradicting the documents here, but I would have, if you had asked me, said that he was present at the September meeting, and was aware of the terms that were presented at the September meeting. Clearly I'm right. My recollection is incorrect, and I take that for what it is. Just to finish on with this point, though, my question was an understanding of the FBI's position of the case, not the ultimate disposition. In other words, as of the date of Exhibit 3, there was no deal on the table. So the question is, what was the FBI's view about the case? So I'm not trying to be difficult. At some point, when you say view, the FBI, to my recollection, thought that what Mr. Epstein did was sordid and disgusting, and that we should proceed. How he proceeded, I don't recall hearing specific views as to the how, as opposed to the we should. Alright, thank you. Let's take a break, 45 minutes, thank you. Off the record. Okay, I think this is where I stopped last time. By misredacted. Alright, we're going to go back on the record. We're beginning after the break at 1:30 in the afternoon. Thank you. Before we get started, yes. You referenced an email from Redacted that wasn't part of the packet. Correct. Is that something that I could see and review, or is there discomfort on that? Yes. No, I am not. As long as we make it on the record. Do you need to do it now, or can we do it during the next break? It depends how long. How long is it? It would just take 1 page. A minute, if you don't mind. Do you want to go off the record while Mr. Acosta... off the record. By Ms. Redacted. Alright, on the record again. For the record, Mr. Acosta has just reviewed an email from Redacted to Redacted, Redacted and Redacted, dated July 18, 2007 at 2:07 p.m. It's one that I described to Mr. Acosta a moment this morning. Do you have any comments? I don't. Alright. Before we broke, I mentioned your statement about SAC Redacted having attended many meetings. That, to be clear, was a representation you made in your March 2007 letter to the Daily Beast, not the written response. Looking briefly back at Exhibit 3 and Redacted, you don't have to read it yourself. Redacted representation that, in her view, the plea offer was completely unacceptable to the victims. Do you believe that she was correct in her view that the victims' views should have been solicited before a plea offer was made? So I would have to think that was one through. That was one through? Okay. There were concerns, and I don't know about the timeline about communications with the victims. They're sort of laid out in the redacted affidavit. So whether or not victims' views were elicited is something I think was the focus of the trial team, and not something that I was focused on, at least at this time. But do you believe, as a matter of sort of principle, that the views of victims should be elicited before a plea offer? Right. Is made. So as a general matter, yes. Okay. I think that the reason I'm pushing back is because you're saying plea offer, and the CVRA does talk to plea offers, as opposed to a situation where deferring prosecution in favour of a state is a very different thing than a plea offer, and at the time, that was not it must. That was depending on the facts and circumstances. That's a judgment call. At least that's how the department, to my understanding, viewed it. And was it also your view that it would have, as a general matter, is a better practice or better approach to talk to the victims before? As a general practice, yes. Alright. Do you think that would have been particularly important in this case, when the proposal involved sending the case back to the state, which the victims were aware had already mishandled the case to begin with? So, there are a few things in that question that I think are packed. Whether the victims were aware and were of the view, from my perspective and my recollection, were of the view that the state had mishandled the case, I can't speak to. Some of the victims were, to my recollection, exonerating him. There was concern that some of the victims were more on his side than on the prosecution side. And so, that judgment call of which victims are notified, and how much I think is something that really is a judgment call that needs to be done, almost on a case-by-case basis, by individuals that are aware of sort of the facts and circumstances surrounding each victim. In a general case, you want to have fulsome communication. I can understand in cases where victims might be giving exonerating information where, or there is restitution at stake, that could be different. And by the people involved, are you talking at the trial team level? At the trial team level, with whatever appropriate supervisors are engaged in the victim notification issues. And in this case, that would not include you, is that correct? That I don't recall cases where I became part of the victim notification judgments. By Misredacted. Did you ever issue an instruction to the trial team that they should not consult with the victims before the MPA was signed? So, not that I recall. I know that there's some instances where after the MPA was signed, I said, I'm directing that we withhold notification for 5 days, or X period of time to work this out. But before the MPA was signed, I don't recall, in all candour, I don't recall discussions about victim notification until after the MPA was signed. I don't know if there's email traffic before the MPA was signed, but I don't recall victim notification issues until after the MPA was signed. Okay. By Mr. Redacted. And one more question on this topic is that prior to... We interviewed other people, obviously, in this case. And we interviewed Ms. Redacted, and one of the things that she told us, she has a recall of a meeting with you present, Mr. Redacted, and Mr. Redacted, where this issue of victim notification was discussed in the time frame of prior to the FBI, and at that meeting she was specifically instructed that we are not going to talk about it with the victims. Do you recall that meeting? I don't recall. If that's a recollection, that's a recollection. I don't recall that. I recall knowing that there were issues around victim notification. I recall, particularly after the MPA was signed, I recall efforts, I believe, to notify as it was being signed. To notify the victims of the upcoming state plea. And I recall discussions, if not discussions. Let me not say discussions. A general concern about the victim notification. What does that do? Because the victim is also a witness, and a potential witness, and in some cases, an adverse witness. And so, how does all that balance out? Okay, well, we're going to drill down into those. Right. Post-MPA issues later on. Right. Sorry, cats are running around in the background. Just now focusing on, right, pre-MPA before it's signed, when the negotiations are going back and forth. Right. You have memory of this topic coming up. I don't recall discussing the victim notification issues. Okay. What would your response be, though, to... Are you aware of the CVRA litigation that went on? Yes. From Judge Mara? Yes. So one of the issues that comes up in Judge Mara's decision is he made a finding that the government violated the CVRA because they didn't consult with the victims. Right. Prior to signing the MPA, and there was a perception, or from his opinion, that the government did this, failed to communicate that in order to eventually keep the victims in the dark and protect the resolution. Why is that an incorrect assumption? And so I would say that Redacted sets out her reasoning in her affidavit. She talks about, by Ms. Redacted. Are you referring to her 2017 affidavit? Her 2017 affidavit. She talks about, I believe she notified at least some victims and it became an issue. And there's concern, when you have this MPA. Whether or not that MPA will ultimately remain is a very open question, because from our officer's expectations, we expected him to plead shortly after that, and he did not. And so, are we going to trial, or are we not, is a very open question. And I think there has to be discretion, where there is no legal requirement. There has to be discretion to judge how much you can tell the victims and when. By Mr. Redacted. Okay, just one other point, and this is that we've reviewed, Ms. Redacted's declaration and the notifications that she's referring to there. Those discussions take place after the signing of the MPA. So, we're just talking about here still, right, just the pre-MPA, pre-signing of that. So, does that change your answer at all? Again, I don't recall the victim notification being issued before the MPA. I recall a lot of discussions afterwards. I don't recall. That doesn't mean they didn't happen. That just means I don't recall them. Was there any concern with you, or among any of the other people involved in this negotiation phase, that if the victims were to find out that we are negotiating this MPA, that it will blow up the MPA? That it will cause us trouble in some way? My focus before the MPA was signed was, here are these teams, and then for the team, go negotiate this. And so from my perspective, it was much more of a, what are the terms, than the victim notification issues around that. By Ms. Redacted. Right, but just to follow up. Right. Did you hear any discussion amongst the people that you were dealing with? That they were afraid that the victims might raise such objections, or go to the press, that this whole thing would be, come to a halt. So I tried to think. I don't recall. I believe we notified the victims in advance of the state hearing, so that they would be aware. We didn't notify them before we signed the MPA to my recollection, but we certainly notified them of the state hearing. And so, I was aware generally of what was being done, but the MPA and what the MPA was the focus, not the victim notification. When part of that. When you talk about... Go ahead.
We're going to get into that plea.
Right.
And what we're...
All right. Right.
A little bit later on.
Right. By Mr. Redacted. Yeah. Bunch of different... I think this is just three people going back and forth. That's fine. I'll put on different voices for all of them.
Oh, Jesus.
So going on from here.
Just one. Can I just direct you to...
Yeah.
Document number 15.
Ms. Redacted. Exhibit 15?
Yeah.
By Mr. Redacted.
Okay, so do you... There was an email that is from Ms. Redacted to Redacted, then forwarded to you.
Yeah.
Do you see the reference in there where she mentions that she spoke to Redacted, or Redacted reminded her, where is it?
Ms. Redacted. It's in the second paragraph. Yeah, no,
Ms. Redacted.
In the middle.
I see it. The middle.
It's highlighted.
By Mr. Redacted. Could you just read that? The agents and I have not reached out to the victims to get their approval, which, as Redacted politely reminded me, is required under the law. Do you recall that email?
I don't recall this specific email. My recollection is a view that there is no requirement to notify because it's not a plea. It's deferring in favour of a state prosecution. And therefore, it becomes a discretionary issue. And what notification is appropriate is really a function of how you interact with victims who are also potential witnesses. And I was aware, I support what the office did. I'm not backing away from it. I'm just saying I can't, 12 years later, reconstruct what the thought process was, other than there was no legal obligation. It was a discretionary issue, and this is how the discretion was exercised.
But do you remember, So, there's two things. Do you remember any discussions coming up about the topic of what we have to do as far as notification in the pre-MPA negotiations?
I really don't. I know there was a lot of discussions after the MPA. I don't recall pre-MPA discussions on this.
Last question on this.
Sure. Misredacted. By him.
The witness. Yeah, by Mr. Redacted. You're getting at least forwarded to you an email from the trial attorney in the case showing that she is concerned about the notification issue, and she's raising at least referencing the head of, CEOs about this issue. Did this ring any bells to you? Raise any?
So from this, I would infer that a discussion was had as to what the obligations were, and whether we had to or not, because... So I think it's fair to infer she is, emailing my first assistant. I don't know what the attachment here... Oh, the attachment here is the term sheet, so to speak, and my first assistant is forwarding it to me in large part so that I get the attachment. And I think from here, it's fair to infer that some conversation or discussion was had. I don't remember the conversation or discussion. My focus was on the terms. I'm willing to accept that the conversation was had. My recollection of the obligations under the CVRA is that they did not attach because this was not an indictment, it was not a plea, and that it was entirely discretionary how we proceeded, and therefore how you proceed is a function of should you notify victims. Yes, but there are concerns because there are also witnesses. There are concerns because we are going out of our way to provide for restitution, and all of that played into a complex calculus.
That was it.
By Misredacted. So you said that there was a view that there's no requirement to notify the victims. Who was that view coming from? I can't speak to person A, B, or C. I can say that if the office thought there was a legal obligation, there are too many professionals involved in this, that if they thought there was a legal obligation to notify, they would have done so. At some point in this process, whether it was pre or post, I know that there was some explicit consideration of what are the obligations, and some discussion of, this is not the obligations, don't attach into indictment, and therefore this is a discretionary matter. Whether that happened in September or in August or October, I can't speak to. But I know that was talked about, and I think later on in the record, there's an email from our appellate chief in a different case that highlights, well, there is this Texas case that just ruled the other way. So clearly, it's an issue that had been talked about, and I recall it being talked about. I just can't tell you the when or with who. And would there have been... You've spoken on one concern. Right. Concerning impeachment of the victims regarding their, financial aspect of the MPA. Would there have been any downside to consulting with the victims concerning, hey, the US Attorney's Office is considering a restitution short of a plea that involves charges in state court? How do you feel about that, victims? So there may not have been a downside. It's difficult to recreate. My understanding, going back 12 years, was that the victims would be aware of what was happening at the state court and have an opportunity to speak up at the state court hearing. And where does this come from? So my understanding is that when he was going to go into state court, that they would have been notified that there was an all-encompassing plea. That state court sentence would also mean that the federal government was not proceeding. But again, in terms of before... Your point is before it was signed. Correct. So that they could have input. Right. Into trying, perhaps, if they wanted to persuade you that was not a good idea. It may have been looking back on it, it may have been a very good idea. I can't speak to what the thought process was then, other than it was discretionary and it was not legally required. But at least as we sit here today, you cannot recall a particular problem that somebody brought up to you and said, we should not consult because of this problem. I don't recall that, and clearly, given the way it's played out, it may have been much better if we had. By Misredacted. In the last 20 minutes, you've several times referred to discussions and we. Right. I want to make it clear that so far, the people who are involved in this case, the Epstein case in your shop were you, redacted, and redacted. Is there anyone else who was involved in those discussions other than those 5? Not to my recollection at this phase. Okay, I just want to make sure. Yes. We understand who was encompassed, right, in that general discussion, right, of the matter. Okay, so on July 26th, so we're now a month after that presentation by the defense counsel to the team, including redacted and redacted, correct. There was a meeting in Miami, and it was, again, among redacted by telephone, redacted, as well as the 2 case agents. Redacted and redacted. Did you know them, by the way? I did not to my recollection. Okay, and also their supervisor, redacted. Did you know redacted? Somewhat. Alright. And they were all in West Palm, of course. Yeah. And then Asak, redacted? Yeah. Do you recall her? Somewhat. Alright. They arrived, or at least the trial team. The investigative team arrived ostensibly to discuss the case. It turned out to be a very brief meeting, essentially consisting of Redacted coming in, announcing that you had decided on a 2-year state resolution, and then essentially leaving without... That is, Redacted left the meeting without discussion. This has been described to us as stunning to the investigative team. They had no idea this was coming. They were completely blindsided. The question is, were you aware that Redacted was going to announce that you had decided on this resolution? So I don't recall that, but I decided and endorsed this resolution at some point. And so the fact that I don't recall doesn't mean that I wasn't at the meeting. I don't recall. But I clearly had endorsed this resolution, and so, his announcement would have been consistent with my decision. And again, that decision was reached without consultation and discussion with an input from the line also. Does that trouble you? Sitting here today, I wouldn't have said that there was no input from the author. So, to the extent that she felt there was no consultation or input, that would. From my perspective, trying to recreate things from 12 years ago, there have been discussions and consultations, and she has spoken with Redacted, and it would have been my guess that views were known and articulated, and there was good communication back and forth. But again, that's your expectation of your people. Is that correct? Correct. Okay. So, and also from our interviews, it's our understanding that you popped your head into that meeting and said hello to the folks. Okay. Gathered. Do you have any, recollection of that? I don't remember the meeting. Alright. I may have done that. And it's not, right. Completely uncharacteristic of you. Right. Okay. It's not. Alright. No, because that was an internal meeting. That wasn't right, or correct, as opposed to the, right, scenario we were discussing this morning. Alright, this deal, and we're not talking about, right, the term sheet yet. 2 major prongs we want to talk about. 1, the first one is for going federal prosecution, right? Going for a state-only disposition, and I talked to you this morning about the 5 ways a case could proceed when it comes from the state. You can either decline it and give it back to the state. You can go ahead and indict, but the guy... Let the defendant or defendants go to trial or plead to the indictment. You can indict, negotiate a deal, although you talked about some of the issues there, and you can also file a complaint and negotiate pre-indictment or negotiate something. Right. So why was it that all of those other options were rejected and the state-only deal was settled on? So let me back up a minute, because I think it was a little more fluid. The way the matter came to the office was the state wasn't doing enough. It didn't provide for prison time. It didn't provide for registration, and then you had the restitution issue. There were legal issues, which I'm sure we'll talk about. There were witness issues, and we could go to trial, potentially, and we may or may not prevail. Alternatively, we could look at a pre-indictment resolution, and at various points, the office went back and forth between a federal pre-indictment resolution and a state pre-indictment resolution. I think you showed me an exhibit where Redacted said a 371 with Rule 11. There was some discussion of other statutes at some point. I don't recall the timeline. And so ultimately, the focus was as an initial matter. How do we get to this resolution with some flexibility for state versus federal? There was a preference for deferring to the state. Where does that come from? In part because the legal issues are to some extent also present in a federal resolution, because that then becomes a precedent for other similarly situated cases. Did you want to avoid a precedent? So, should we talk about the legal issues? Because we say we keep coming back to the legal issues, but alright, talk about the legal issues. So when I was at Civil Rights, one of the areas of responsibility that I had was trafficking. I was very supportive. We set up some of the first human trafficking task forces. I thought Civil Rights really became aggressive. I think Redacted was one of the point people. We brought in Redacted to be a point person on human trafficking. One of the background issues that informed the time and all those prosecutions and also the development of the trafficking law was, what is the distinction between trafficking and solicitation, and what is the distinction between a truly federal case and a local case? Because there was a lot of concern at the time about federalizing something that is traditionally local. Now, that was 12 years ago, and I think that those concerns are no longer in play today, nearly, and certainly not to the extent that they were 12 years ago. This was the state of play at the time you were the AAG for... Hello, Dexter. At the AAG and afterwards as I was US Attorney to some extent, there was a lot of discussions about federalizing state issues generally, and certainly in the legislative issues that went back and forth. That was a consideration. Wasn't that trend very swift as of... Was it '06 when the Adam Walsh Act was enacted? So sure, I think we're treading in a certain direction. Alright. And I think that trend has continued and accelerated, but these were valid, in my opinion, considerations at the time. And one question to be considered is, how would a court look at this? Because different judges may look at these statutes differently. And how would a court consider federal nexus issues? And so, that was, to my mind, an important consideration, because this was, at the time, to some extent, uncharted territory. And while we might prevail, and probably would prevail, we may not have. And how is that weighed against a certain plea with registration that would make sure that the public knew that this person was a sex offender? Okay, a couple of things. One, did you engage in that discussion based on your experience with Redacted? Did you engage in that kind of conversation? I don't recall who I may have talked to, but this was when you will see in the record reference to legal issues. These were the legal issues, at least in my mind, but that's referring to. But did you sit... I mean, not to be silly about it, but... Right. Did you sit in your office and ponder them, or did you in the context of, we would have discussed them? Alright, we being you and I, and whether it's redacted, or redacted, I wouldn't have sat and pondered them on my own, but we would have had some level of discussion about these. So conversely, is it your understanding that those three guys understood from you at least your perspective on these legal issues? Let me push back. Those three professionals, because they are... Oh, yeah, I'm sorry. Well, in this context, it's colleagues, yes. Yeah. So there were two large buckets of issues. One was the witness issues, and on those I would have deferred more to folks that are experienced trial prosecutors. The other one are these legal issues. And you see it with the Fed, with the reference at the very beginning to the federal nexus. And you see it throughout where these were discussions that we had, and from the very beginning, what is the federal nexus, and how do we make it clear that we are not stepping on something that is a purely local matter? Because we don't want bad precedent for the sake of the larger human trafficking issue. Did you have those conversations with your three subordinate colleagues in this case? I would have had those conversations with those colleagues. Whether it was with all three, or with two, I can't recall. But I would have had those conversations. And do you recall whether anyone among them pushed back, as, for example, Redacted indicated his view on some of those issues? So I don't recall specific pushback. I can say where we concluded, which is there, we are comfortable enough with the law to believe that that if we need to go to court, we can do so ethically, and we have a good chance of winning. Because if we could not go forward, of course, then we just can't go forward, right? No matter what outcome you want. Was it a slam dunk? Was there some legal risk? Yes, there was some legal risk. Mr. Acosta, you used the term a roll of the dice in your press conference. Yes. There's a different... I mean, at one end you have a slam dunk. I will submit that no criminal prosecution, right, is a slam dunk. Correct. Likewise, I would ask you to commit on whether any prosecution is really a roll of the dice, given that a prosecuting authority, in this case the US Attorney's Office, will have always done investigation, persuaded at least a majority of grand jurors that there is sufficient proof to bring an indictment. Right. And so on. Would you still hang your hat on a roll of the dice hook? So, I don't know if I would use that exact phrase. Alright. But let me just say, because you put in grand jurors, from our perspective, sitting in the office in 2006 and 2007, this is a case that someone comes to you and says, this has been presented, we have no reason to believe the state attorney acted, we're not happy with what they did, but we have no reason to believe that there was funny business. Misconduct? Misconduct. Alright. And let's assume that there is no misconduct, because you don't want to assume that again still. So the state attorney took this, reviewed it, presented it to a grand jury, and the grand jury came out with this kind of recommendation. That at least is indicative of some other authority looking at this and making a judgment as to what it looks like. Are you aware that at least at the investigative and line assistant level, they had understanding and reason to believe that the state prosecutors had put in witnesses into their grand jury and set about impeaching them? I'm not right. Suggesting that this is misconduct, but it's a way of approaching evidence before a grand jury. And if they did that, it would be perhaps charitably for the purpose of making it abundantly clear to the grand jurors how the witness would fare. Right. Or not fare under aggressive cross-examination at a trial and so on. Right. So, were you aware of that at the time? I was not. Right. Oh.
You are not. Right. Okay, there we are. You are not aware that there was an actual concern and understanding that there was by your team? That there was a concern that they basically tanked the case. Tanked. Yes. So there was... You didn't know that. I was aware of a concern about how the state attorney, how aggressive they were. Right. There's a distance between how aggressive they were versus tanking the case. Right. But I am telling you the concern by your people at the ground level. Right. Was the latter. Understood. Okay. Aware of lack of aggression, tanking the case, very specifically. I mean, there might have been, hey, is there... This looks really good, or really odd, but you've given a level of granularity as to highly unusual conduct. So my point, there is at least a perspective coming out of the state. There are legal concerns. We believed, at the end of the day, I thought we would prevail, but they're valid. And then you overlay that with witness concerns, and concerns as to how juries, which were different in 2006 on these issues. What do you base that on, by the way? It's because you're not a trial attorney anymore. So experience with how juries in South Florida looked at these matters, and with how South Florida looked at the Project Safe Neighborhood. I'm sorry, it's Childhood. Project Safe Childhood run initiative generally, and so there have been prior instances where we had talked about this and we had gotten some pushback from within the office or within the FBI, or from within the FBI. Sorry. On what? On sort of sex cases more generally. And pushback in what regard? Where should we put our resources? And so there was just general pushback. Okay, but there are a couple of things there. One is the petite juries, and which, right, I still like the answer on, yeah. And then the other is the FBI being loath to muck around with these cases that they were not, yet. So, engage with. So let's take them one at a time, and in all candor, I think we're looking at this through a 2019 lens. At the time, and I've said this in different forms, but Weinstein was known and about, and actions weren't taken, and Bill Cosby was known about, and they're each, go with me, they're each different, alright. But I do think the public looked at these cases differently in 2006, and there are at least some individuals, I'm not saying it was the right view, but there are at least some individuals who would have looked and said, this is a solicitation case, not a trafficking case. Alright, who in your office, who in the US Attorney's Office ever said that? So this came up in the context of how would the victims do in court? And it wasn't just, how would they be impeached, but how would jurors look at the fact patterns around this generally? And who was talking? I can't say. I know that it was discussed. I can't say A, B, C, or D. Well, it wouldn't have been D, because D would be redacted, and I think you would agree with me that she would not... I would agree. Concede that. I would agree with you. Alright. With that, but my point is that when we're talking... So, when you're looking at victims in court today, I think it's fair to say that the way we approach, there's been a lot of changes in victim shaming, and the degree to which all of that is permitted. The degree to which I think the public understands that girls, minor females, may be scared and may testify differently. And I'm suggesting that it's important to sort of think back to 2006 and understand that these issues may have been viewed differently. You have not, since leaving the US Attorney's Office, been engaged in the investigation and prosecution of handling in any respect of child sex crimes. Is that correct? That is correct. So, on what do you base this? Is it your cultural observation? Your perspective on the evolution of popular culture, not in a derogatory way, that leads you to that assessment? So, on a view, certainly the law has changed, and the law has become much more aggressive. So, for example, I believe the law on proof of age has changed, where proof of age is no longer required. The law has, but the case law even at this time was already... What was reasonably clear on that? Was reasonably clear, and certainly moving in that direction. Correct. Wouldn't you have wanted to be at the forefront of this? So I believe I was at the forefront of trafficking issues, and I think if you were to look at my civil rights record, I really was at the forefront of trafficking issues. Even the US Attorney's Office had a very robust, as we discern it now, a very robust initiative. It maybe wasn't a formal initiative, but commitment to prosecute these cases. Correct, and I fully supported that. All the more reason why, if there is an issue, and there is a potential for some judge, rightly or wrongly, whether I agree or not, because you can't always predict, even though you think you'll prevail, you can't always predict where holdings go. Are you talking about on appeal, or in trial to, right,
to issue a negative precedent on travel for purpose of, or on federal nexus, and if you think back at the time, on a pier, there's a lot of case law on commerce clause and federal nexus. Right. And so, I think that is an important and valid factor that goes into the decision-making that assess the risk of trial, not just from how the victims will testify in this particular case, but also what this means to the greater effort. I understand that completely. What I am not hearing is where a voice other than you and your team in this case has been heard. Like Redacted. Did you and talk to him about these issues? Because not CEOs, not two. Was at the forefront of, not my recollection. Alright, wouldn't...
Mr. Todd, let Redacted finish her questions.
The witness. Okay, sorry. Ms. Redacted. We're all... The witness. I apologize. Ms. Redacted. We're on a mutual role here. The witness. Okay, by Ms. Redacted. But wouldn't... If you had those concerns, perfectly well-founded, why not reach out and engage with CEOs and see what their assessment was about the vulnerability that this case might expose your office to? So I can't reconstruct that 12 years later. One interesting question is, would CEOs have come to mind versus civil rights crim? Because coming from civil rights crim, my primary trafficking contacts would have been, did you pick up the phone and not call them? Not to my recollection. So I guess what I'm getting at is you, based on substantial experience and a commitment to these cases in your office, the US Attorney's Office, have formed your own analytical analysis, your own analysis legally. You've told us you've discussed this or made those issues and concerns known to the people who were below you, at least immediately below you, and that's where it is sort of rested. There was not an effort to go out and enhance or add to your understanding of the case and legal issues. So to my recollection, I don't recall, and we'll get into perhaps, from my impression, I actually thought I was being more aggressive than Main Justice would feel comfortable with, and more aggressive in what respect? In my interpretation, and how comfortable I was going forward with that Main Justice, and we can get into that, but I thought I was being more aggressive, not less, and so I had these concerns. I did not vet them at Main Justice. Okay. When you said more aggressive, are you talking about the fact that you crafted this state disposition, or that you were more forward-leaning on the potential of prosecuting Epstein federally? More forward-leaning. And yet you didn't. You didn't lean sufficiently far forward to actually pull the trigger and have an indictment returned. So I will push back on that, and that, from my perspective, we were leaning forward, because we did prosecute him by deferring to the state, and ensuring that at the state... Alright, he had a sentence where he went to jail. Alright, okay. I want to sort of move on. I want to ask you a question about 11C1C, please, that you mentioned earlier. Okay. And sort of alluded to here when we, talked about judges. And we talked about dismissing charges from an indictment. What was your position as US Attorney with regard to the binding pleas in a 11C1C plea agreement? We use them very rarely. But why? As a typical matter, judges do not like them. And was that something that, as US Attorney, you engaged with the judges on? Or was that simply a matter of seeing what they did with them? It happened before I got there. I suspect it continued to happen after I left. Alright, okay. That said, were there some occasions in which the office, if you recall at all, did do 11C1C? Their plea agreements? May have been, I don't recall. Okay, alright.
Mr. Redacted. And Redacted, before we move on to...
Miss Redacted. Yes?
Mr. Redacted, another issue. Can I...
Miss Redacted. Yeah, I'm...
Miss Redacted, go back a second.
Miss Redacted. Still with federal. I'm still on the federal prosecution, but go ahead.
By Mr. Redacted. We had talked about You talked about the state grand jury and how that decision informed your decision, and you said, well, what state grand jury did with this? What was your understanding of what this was? Like, what exactly the state grand jury looked at?
So let me back up. I said it was a factor that informed, not just,
I understand,
determined. So my understanding is that at least some core amount of facts were presented, and I understand that since it was at the state, the FBI may have found additional witnesses. But when it was presented, the very reason the office took it in the first place was because it was presented to the state, and it went to a grand jury. And the recommendation from the grand jury was for a statute that would not require jail time, and that seemed wrong. But the very fact that it was presented to a grand jury certainly was one of several factors that we considered, because it at least indicated some level of how individual jurors may view this.
Do you have any recollection that the state grand jury presented a single witness, who, as Redacted talked about earlier, that they impeached?
I have. I have read that it was a single witness. Since then, I don't have an independent recollection of that.
Okay.
By misredacted. And how familiar were you with Florida state criminal procedure? It depends what area. Well, you never practiced there, right? Correct. I forgot what law school you went to. Not Florida. Not in Florida. And you were not a member of the Florida bar. Correct. So really, any knowledge you had would have sort of been picked up. I should point out that a number of authors in Florida are not a member of the Florida bar, so that's not unusual. Oh, okay. No, I'm not. Right. Suggesting right. Otherwise. And in federal employment, you can move from right. Yeah. So I have been U.S. attorney for quite a while, and then I think we would have been interacting with the state system sufficiently, and if there was something that I had questions on, I could certainly ask. Were you aware that in the Florida system, grand juries were not required to be used to bring federal criminal charges except in capital cases? Yes. Okay, so even bringing a case to a grand jury in a non-capital context was somewhat unusual. An indication that there was some concerns or something, so the state attorney, presenting it in the best possible light, is looking to test the case. Alright, and without getting into any substance, did you at any point become aware of the kind of reaction that the line author redacted was getting from the federal grand jurors to whom she was presenting? I did not. Alright. Another aspect of concern that I think you mentioned in your press conference was the concern about labeling or putting the victims, in a position where they would be labeled as prostitutes, right? Do you recall? I'm not sure, mentioning that. I phrased it that way, but I take your... We'll defer to the record, right. But you did express concern, and our understanding is there was some expression of concern in the U.S. Attorney's Office among the folks about the victims having to self-identify or, right, admit that they were sort of prostitutes. The disposition that was reached in the state, and that avoiding that was something to be desired. Yes, right? Yes. The charge to which Epstein was ultimately required to plead guilty did just that. It was a solicitation to prostitution of minors. Did that factor in at all as an issue of that has not been addressed at all? Right, by the state disposition? So I was aware of and signed off on this 3-point. The term sheet is in here somewhere. Term sheet. In terms of the negotiation over which state statute was used and which victims, that is something that to my understanding, was being handled by Ms. Redacted, and from my perspective, she would certainly have had sensitivity to that. And do you have any idea how those three counts or charges were reduced to simply one? I do not. That would be a function of the course of the negotiations. Why wasn't any reasoning for this disposition, deferring to the state, set forth in writing? Why didn't anyone do a memo explaining what your reasoning was or what the officer's reasoning was? I can't speak to that directly, but I can say that it would have been unusual. I don't recall other cases where there was a, this is the reason for our disposition type memo. At least, not memos that came to me. Okay, I'm showing you two, and the caption is all that's relevant here, but there are two memos that are both dated February 2006 and March 2006. One of them is in fact addressed to you from Redacted, and it attaches a memo which is a require for pretrial diversion to resolve case against an individual named Ronald Sasse, S-A-S-S-E. And it is a child pornography possession case in which the conclusion was that the defendant merely possessed it, and that it was a case that should be resolved by pretrial diversion. And I'm just only bringing that to your attention. Right. As well as a second one that I'll show you, to show you that there are cases involving, child sex crimes, where the office did see fit to set forth its analysis and reasoning for the proposed result. The second document, dated February 15, 2006, is a memo, not to you, but to Redacted, in his capacity as Chief of the Criminal Division, and it requests authorization to enter into a plea agreement with a 5-year cap, and it is a C1C plea, and the handwritten notes indicate that the supervisors concurred in it. Again, I'm simply suggesting that there are at least some examples where the office, in these kind of cases, right, did, so put it to paper. So I can only speculate. And questions I would have is, to what extent was this put on paper? Because it was a case that Redacted or others were not involved with. So this was the way that, in this case, the chief of the, the economic crimes, or in this case, Redacted, is chief of the criminal division, we're communicating information rather than walking in and having a discussion. We're just communicating it on paper as a way to obviate a discussion. In this particular case, there was discussion, there was communication, and so a memo to sort of establish. In other words, is this a required approval memo, or is this a memo that says, in lieu of getting together, where are the facts? Let me know what you think. Alright. And was there not a practice, or even a requirement in the office, that plea dispositions should be memorialized in writing with the rationale? So, to the extent that a line attorney might be seeking permission from a supervisor, on a plea disposition, I would think that they would communicate that in writing as the cleanest, most typical way when you've got 20 or 30 line attorneys and one supervisor. That is not necessarily the only way, and certainly as US attorney, I don't recall a practice of memorializing to me what plea dispositions would be. Okay, and in this case, you're involved in the case, right? And in this case, I was involved. And so to be clear, I'm not saying that I disagree with this, and I'm not walking away with it. And so, to the extent that I may have, in a meeting, said this looks good, and said this looks good, that may have obviated a need to. Alright, write that up. Okay, thank you. Another aspect of the state resolution that raises concern, and let me make clear that many of our questions are framed in this way, but we are also reflecting a concern that's been expressed in the press, and in the public, and by others. I understand. Understood. So, understood. We're sort of coming through that lens. So, another aspect of the state resolution that raises concern is, doesn't it appear that by sending this matter back to the state, there's more federal interference, more federal involvement in the state process than there would have been if you had just kept the case? So in hindsight, one of the issues I think in this case is after the agreement, and we keep calling it a non-prosecution agreement, and I kept saying, call it an agreement to defer in favor of state prosecution. A DPA instead of an MPA? Right. Why wasn't it called a DPA, by the way? I don't know. There's one email where I suggested putting in reference to petite policy. Right. And redacted said, looks strange, take it out. There's another email in the record where I keep saying, everyone keeps calling it an MPA, call it a deferred to state. So I can't say why not, but it's an important distinction. But if you had said it, I don't want to go, too far afield, but if you had said, call it a deferred prosecution, right, agreement, they would have changed it, right? They would have, and I actually asked that we have a clause based, I don't have the independent recollection of this, but based on the record that we include a clause saying that we were doing this in light of the petite policy to defer, and redacted pushes back and says, I haven't seen that, and he's the local expert, so I defer to him. I take responsibility, but it's an important distinction, and so, I'm sorry, I just lost track of your question. We were talking about, doesn't this involve more federal interference? Could I grab a Red Bull from you that I bought?
Mr. Heron, yeah.
The witness, sorry, just a... Misredacted, do you want to take a 5-minute break? The witness, would you mind? Misredacted, not at all. The witness, yeah. Misredacted, call it please, at any time. The witness, let me grab the Red Bull. Misredacted, off the record. Off the record. By Misredacted. Okay. Time for a little break of my own. Oh, the kitties are so well behaved. Dexter is sat on my desk, just next to me. Clara is sat at the foot of the cat tower, as you can see there. I think they're doing very well. And I think we're making good progress. My aim is to get to page 300, so it'll be to finish what's on this document, and then finish the next one as well. And then it's 112 pages. That is the rest of it. So I'll be probably doing that in another stream, because I think last time I did this, my throat almost broke. Well, my voice was cracking. It wasn't healthy, and I had trouble recording the day-to-day stuff the next day. So may have just been how I was feeling at the time. Hopefully that's the case, because I have done the absolute long haul before, and I'm more than happy to do it again. I just need to be healthy and physically capable of it. Alright, thank you. Alright. Back on the record. So, Mr. Acosta, I was asking you about, didn't this resolution end up injecting the feds into the state business in a pretty aggressive way? And so what I was saying is, in hindsight, one of the issues here is, I think this would have gone very differently if, after the agreement to defer in favor of state prosecution, all the victims knew about this. They had gone into state court, he had pled October, whatever the date was, had been sentenced, had served his sentence, and case over. And so, to the extent there are lessons learned, an attempt to backstop the state here rebounded because in the process it got convoluted and complex and ended up being arguably more intrusive than it would have had this just been, here is what we'll do, if you go back to the state and work this out, but would that have required or depended on cooperation from the state authorities? So I think I was clear, and my recollection is this was an issue where I said it is up to you, and I edited a few parts of this. I got involved selectively. Exhibit 21B is... Oh, your edits. Okay, so before I say I think, let's go to... But 21. But before we talk about 21B, as a general matter, you talked earlier about the sort of more typical usual way in which the US Attorney's Office and local authorities, prosecutor authorities would work, and that is cooperatively, and would decide who gets what, and, right, who has what responsibilities. Here, there was not such cooperation, apparently. There wasn't, and I was going to say, to my recollection, we can look at whether it's in 21B or not. One of my edits was make it clear that it's up to him to figure this out with the state attorney, because we as federal prosecutors are not going to walk in and dictate to the state attorney. But in effect, you did. You did it through Epstein. I understand, and so, in an attempt to reach a resolution, particularly as convoluted as this got, I do think a lesson learned is that it ended up perhaps being worse than if we would not have in the first place. Something my team, we very much thought that it was important that he go to jail, that it was important that he register. How we got to that ending is unusual, and as an attempt to factor in, here are all the issues around the federal statutes, the concerns about trafficking law. Here are the victim issues as to trial, and how, here are all these things. And so on the other hand, deferring to the state appears logical. On the other hand, the way it played out was a lot more confrontational with the state than I would have hoped, particularly because rather than go back to the state and work it out, in the subsequent collateral attacks, they almost tried to state to circumvent and to get the state to circumvent and undermine our agreement. And that was, when you say they, you mean the defense team? Yes. So you could have obviated that whole thing if you had just offered the same result, which would be a plea to a criminal charge with, for sake of argument, a 2-year cap, which would have required a C1C plea. Right. And you get your restitution because federal law requires it. They would have been able to proceed under 18 U.S.C. 22.55 anyway, and he would have gone to jail and been registered as a sex offender. All just within the normal course of doing business as the U.S. Attorney's Office. Why not pursue that? Who was calling the shots that said, yeah, we'll do it, but it's got to be with the state? Was that the defense? So something that wasn't the defense. Something that I think is important to sort of lay out here is the term sheet was developed really early in the case. Excuse me, it's dated. Is presented to the team by Redacted on the 31st of July. Do you consider that early? So let me clarify from my perspective. It was developed and approved by me before I became involved in interactions with the defense team. In the sense that you only met with the defense team for the first time, in the person of Ken Starr and Jay Lefkowitz and company on the 7th of September, and it wasn't the 7th of September 2007. And that's important because it goes to, there was a lot of buzz in the media. Did they influence this outcome? To my recollection, they may not have even been attorneys of record in this case, and I don't know when they came onto the case. Well, there's an email in the package that indicates that you got a call from K&E. Right. On or about the 6th of August. After the term sheet was presented. And so I say that because we can, and probably will talk about whether those terms were the best judgment or not. But once those terms were agreed and approved, with the exception of the 24 to 18 as a material, and then we can talk about how that happened, we stuck, and I backed the office, and I backed Redacted in her negotiations on these. And so, I think that's important to note. I understand, that's not, for the moment, the focus. Fair. It's the terms themselves, and in this case, the state court disposition. Everything that you wanted to get with the state court disposition, you could have gotten with a federal plea. Much more easily. We could have, and there was certainly some consideration of a 371, and that may be, in retrospect, it would have obviated a lot of issues. So who said no? That's not so acceptable. So there is emails that at that time Redacted spoke to me about it. I don't recall, but I'll take responsibility for
for favoring or not for favoring, but if that's what happened, I will take responsibility. From my perspective and my recollection, there are two factors here. Well, I don't know if it's two factors, but at least two factors. One, concerns about how this interacts with federal law, and what precedents this might mean for other trafficking cases. Two, a Southern District's general dislike for Rule 11, and then third, there were other federal statutes that were considered at various points, and I remember looking at those and saying, yeah, it doesn't quite fit. Two, just to be clear, that process of looking for the square peg that, would fit into the round hole of the 2 years that had been committed to was a process that came before the MPA was actually negotiated, at a time when Redacted was working with Defense Counsel to see if there was a federal charge that could be within the 2-year correct scope that would allow Jeffrey Epstein to serve his time in a federal facility rather than in a state facility. Is that correct? Is correct. Okay. And I recall at least one of those ideas, and I recall that my general reaction to it was, we're pushing the law that just looks odd, and we don't want to go there. Are you talking the assault on an airplane, or the obstruction of a witness, or... my recollection is not about the assault on the airplane. Okay, but about his home being a special maritime jurisdiction. Oh. Which is... no. Definitely square peg and round hole. Right. Correct, but there was... So I guess Is it accurate that, from your standpoint, a 11C1C federal disposition was not going to be acceptable? That that's not something that you would approve? It would have been unusual. I don't recall with specificity, but I can, based on circumstances, infer that it would have been unusual, and I would have looked at it and said that this isn't typical. I'm not comfortable. So why not offer the 5-year hit and say that's it? I wish I could speculate. I mean, I could sit here and speculate after the fact. I can speak to what I recall, I can speak to what I approved, I can speak to the considerations that went into it. There are all sorts of things that, in hindsight, we may or may not have done, which may have worked out well or not. I can't answer that. So I guess the big unanswered as yet question is, why was there a fixation on the 2 years when that's not something that comported with anything that was possible in the federal scheme? So, speaking to the 2 years, I don't remember with specificity. Let me give you my general recollection. And then let me speculate. My general recollection is that there were earlier charges, you all may know those in more detail than I do, but there were earlier state charges that were contemplated, of which there is no public record. There is. I don't know if there's a public record or not. I can just say my recollection is that there were earlier state charges that were contemplated. The state attorney chose to not pursue those earlier state charges and take it to a grand jury. From public information, my understanding is that's why Chief Redacted became upset. My general recollection is that the 2 years represented what he would have received if the original recommendation, or the original view of the state attorney's office, had gone through, and it hadn't been brought to the grand jury, and I would sort of point to, in this Exhibit 3, I thought it was in Exhibit 3. Somewhere, there's a reference to, as you can see it, Exhibit 3, page 3, as you and the agents conceded, had Epstein been convicted of a felony that resulted in a jail sentence and sex offender status, neither the FBI nor our office would have interceded. But that is completely silent as to what those original charges may have been, or how they related to... I understand. Okay. And so, to close the loop, my understanding is that those 2 years reflected what that would have been, such that the case would not have come to federal authorities in the first place. Okay, where did that information come from? Who said, oh, those charges would have resulted in a 2-year sentence? Was that something that was analysed by your office, or did it come from Defense Counsel, or from who? I can't speculate. It had to come from someone. It did not come from you, is that correct? So I would not have the knowledge to know what that charge would have resulted. As an initial matter, a penalty that says up to blank years is rarely that number of years, right? Right. By the time you apply guidelines and all that, and so I would not have the knowledge to know how to calculate that state sentence. And in fact, were you aware that Florida did have its own state guidelines? Sentencing guidelines? Generally, I know that, right, there was a process, right. Might I at some point have said, Mr. or Mrs. or Ms. Orsa, or management team member, if this had been done the right way in the state, what would he have gotten? And someone comes back to me, possibly, maybe someone at some point has said, look, this would never have come to us if it was done the right way in the state, and this was the term that he would have gotten. At some point in this process, my general understanding is we got to that 2 years based on not random, but based on this was the calculation that he would have received. Right.
And to make sure we understand, is that your actual recollection, or is it your belief based on what you know happened, that's the way it happened? So it is my recollection of my understanding, which is convoluted, so It is how I recall viewing the term sheet when I approved it. Okay. How we got into... And so, if we got to the term sheet, it's 21. No, it's not. It's one of these exhibits.
Mr. Redacted. 15.
By Mr. Redacted. Thank you. 15. 15. So, if we go to the term sheet, Epstein pleads guilty. Contended to an information follow, charging him with... These particular statutes I am not familiar with, but I would have assumed that either Redacted or someone else would have selected them appropriately. It makes a binding recommendation to serve at least 2 years in prison. Let me back up if I could. Those 3 statutes, did you understand those 3 statutes to be the 3 statutes or to be the statutes that the state originally was going to bring? I can't speak to that. You don't know? I don't know. So, you don't know what the statutes were? Yeah, okay. Yeah, it makes a joint binding recommendation at least 2 years in prison. My recollection of my understanding, when I reviewed these terms, is that reflected what he would have received if the state had gone through with an initial charge, and from our perspective at the time, that would have obviated the need in the first place to have engaged federal authorities. Agree or disagree with the logic? I'm trying to explain the logic. No, I understand. Thank you for that clarification. Is it... You posited a couple of possibilities that you might have said. Gee, what would... Right. He'd be looking at if... Right. The state had done what it originally set out to do, or was supposed to do. Is it... How also likely is it that someone came to you, one of your people, and said, hey, I suggest we go with 2 years because the same reason it's... In other words, it came from, right, somebody else to you, and you agreed. So it's very different to... So it's very difficult to reconstruct this in retrospect, in part because I don't want to leave the impression that there was one meeting where this was discussed. As opposed to, you're sitting across the hall from someone, you're sitting down the hall from someone. There are ongoing discussions. How do we resolve a matter that has some thorny legal questions? Some difficult victim witness questions. And this is the kind of back and forth where I might have indicated a concern. Someone was trying to address that concern, or I might have asked the question. It's... Well, you've already told us that you did express concern, right, about the case, and you were having conversations with Redacted, possibly Redacted, correct? Correct. And is it possible, is it reasonable that one of them might have come up with a solution for you to your problems? And that's the point I'm trying to make. It's certainly possible, and it's difficult to reconstruct that 12 years after the fact. Alright. I want to go back to wind up this. Wind up this? This concern about engaging the federal system into the state process. 21B is the exhibit, that is your comments, really, on the very final version of, right, the MPA on September 24th, and the language is quite striking to us in this regard. Looking at the first email there, you've talked about deleting the petite policy portion upon Redacted's recommendation, and inserting global resolution language which you proposed. And then you say, I'm not comfortable with requiring the state attorney to enter into a joining... Let me redo that. And then you say, I'm not comfortable with requiring the state attorney to enter into a joining recommendation. And then you propose essentially taking out a mention of the state attorney's office regarding the sentence recommendation. And then you also note, I'm not comfortable with requiring a state court to stick with our timeline. And you ask that the reference be softened. Your term is to soften. You also use soften below when you talk about a concern about making Epstein an agent of the US regarding negotiations. So you're really... And then at the very top, in the latter follow-up email, you express concern about, do we really need to set a date for his reporting? I'm very nervous about that. If I were a judge, I would be upset by the federal government telling a state court how to manage their calendar. Sorry, Dexter, you're distracting me. You good boy. Can we delete? Right. So clearly you're very mindful, right, of the importance of not injecting the federal sovereign into the state sovereign. Correct. Fair? Alright. But yet, this whole setup, the whole MPA, did require certain actions to occur. However, they came about in the state because of the federal requirement. Yes. And why was that a good idea? In hindsight, the complexity that this took on clearly is something that if I was advising a fellow US attorney today, I would say, think it through. I do think it would have played differently if he had actually not done all the collateral deals and stuck to what was... But that came later. This is before it's signed. It came later. But let me at least say that and stuck to October 26th. But look, I understand your point, and the response that I can give was, we had these concerns, but we also thought it was very important that he serve some real punishment, and that he register. And whether we balance that or not, a lot of people are going to be questioning for a long, long time, but that's how we balanced it. Because the state disposition was not a precondition to achieving those two objectives, you could have done it with a federal plea, serving time, arguably, and the offender registration. Arguably, we could have it done... No, how we do that? Arguably, we could have done it with a federal plea if judges would have gone... If judges would have gone for Rule 11s, which in the Southern District they tend not to, but arguably Okay. I just wanted to... And again, this is a hindsight thing, but yes, it is. But what we're focusing on is not so much the hindsight as the... At the time, did this make sense? And it seems that you all were putting in so much effort, and it was so hard to make this come together and work, that it's striking that it didn't collapse of its own weight. And to that point, let me say, it's also, if I had to speculate, one question that I'd ask is, everyone's putting in all this effort. Redacted put in a lot of work on the negotiations with the defense counsel that were somewhere between zealous and difficult. Meaning defense counsel were, between zealous and, difficult? Yeah. Whether they're zealous advocates or cross lines to rude, we can have conversations about. And at what point, would it have proceeded differently if folks said, let's take a big step back and let's seriously reconsider. But everyone was very, let's get the job done, let's put him in jail, and I'm speculating in hindsight. But could you not have pulled the plug at any time before it was signed? I mean, clearly by the morning of that day, you were calling for some edits that really seemed to reflect a real discomfort. As you identify. Again, I'm supporting the point you're trying to make that we were focused on getting this done. I'm real concerned that he would not go to jail. And a question that I think is a valid one in my mind is, did the focus on, let's just get this done and get a jail term, mean that we didn't take a step back and say, let's evaluate how this train is moving? From my perspective. Okay. I just want to sort of round out the little bit of this. The state-only resolution. You use the term a couple of times, backstopping. What do you mean by that? What I mean by that is a sense that the state wasn't doing enough, and perhaps backstopping is a polite way of saying encouraging the state to do a little bit more. All right. Did you have any discussions about whether this disposition comported with the Ashcroft memo, in that you were hunting to the state for a minor charge? For a fairly minor charge? What your office had already understood from the evidence was a quite wide-ranging scheme of predatory, behavior regarding minor victims? So I don't recall a discussion around the Ashcroft memo. I would characterize what we did differently, in that there are any number of instances where the federal government or the state government can proceed, and state charges are substantially less and different. And on a fairly regular basis, the federal government but stands aside and lets the state proceed. But in this case, you actually had an active investigation that had been proceeding for a year. So let's take the drug context, where there might be any number of active investigations where the federal charges can be rather substantial, but ultimately the federal government says, just let the state proceed with this. Or violent crime cases where the federal government could bring gun charges using felon in possession or another mandatory minimum. But the state goes forward with... So in that sense... But the state goes forward with what? Forward with different charges that have a lesser term. And so I don't think it's unusual. We can talk about, whether this was the best disposition or not, but I don't think it's unusual to have fact patterns that are under investigation that proceed in state court, where the disposition is different than and would have been if it had proceeded in federal court. All right. Do you have anything on that? Redacted. On the 2 years or something else? Redacted. No, I'm going back to the 2 years. Redacted. Okay. By redacted. Did you believe at the time, if this was part of your thinking, that because it was so important to get sex offender registration, and even later develop monetary damages for the victims under the state plea agreement, that pretty much the only thing that the federal government had to give up in this negotiation was jail time? If you wanted, right, 3 things, correct. You said jail time, sex offender status, and some kind of restitution or damages. Right. Mechanisms. Sex offender registration, there's really no give there. You either register or you don't. I'm being binary. Right. Again, I'm sorry. But it is binary, so it is binary. Yes. And likewise, right. Monetary recovery provisions. So really, the only thing to negotiate is time, right? And so your negotiation is, why did we not start at 3, so we ended up at 2? Well, that's a consequence of what... So, I was asking. So, again, my recollection is I understood this to reflect what he would have received as opposed to some arbitrary. Let's start at 3 so we end up at 2. I'm sorry, you have a question? No, go ahead, I'll get to my question. I also, from my perspective, was, early on when we set firm on the 2 years, I thought 2 years would have been the right outcome. We ended up on 18 months. I can't say how. There's some documents that might help, but I was at least initially firm on those 2 years. Right, so when you say, I thought the 2 years was the right amount, is that based on your understanding that that's what he would have gotten in the state? Correct. Alright. And the point I'm trying to convey there is that this wasn't, to my understanding, a random number, but it was informed by, this is what he would have received, and therefore it is a reasonable, agree or disagree with the analysis, but it wasn't an informed number to begin with. By redacted. But you don't recall how that analysis was done, or who conducted that analysis? I don't recall that. By redacted. Or even whether it was accurate, actually. I don't recall that. Alright. By redacted. And I understand the explanation. Right. And, right. What it's tied to, but was there any consideration? Because this case, right, was not about 1 or 2 victims. It was a very large scheme by this older, wealthy man to essentially turn minors into prostitutes, have sex with them, oral sex, get other people involved. You've described it in prior statements as grotesque and deserving of punishment. What I'm not hearing through this process is anybody taking a look at his overall conduct and saying, what is the appropriate punishment for this man's conduct? Was there such a consideration, and did you feel that 2 years adequately punished him for the scope of his conduct? Fair question, and perhaps going back to where we started, which is petite. To my mind at the time, there was a distinction between what would be the adequate punishment if this was a purely federal case versus what is necessary so that it is not to put it in petite language, a manifest injustice, so that it wouldn't have come to the office in the first place. And that I think is the important distinction, because if the 2 years is what he would have received, and therefore it would not have come into the offices under petite, then if there is a state disposition to that, that is one possible outcome. It would be a different outcome if this were truly a federal prosecution independent of the state, which goes back to the point I was making about concern about a federal precedent with this kind of sentence, because then when the next person comes along, they say, well, here is the precedent under 371 or whatnot. And so this was, rightly or wrongly, and I understand the pushback, an analysis that distinguished between what is necessary to prevent manifest injustice versus what is the appropriate federal outcome to that. Agree or disagree with the logic is one thing, but did I explain the logic? Yes, you've explained the logic. Okay. And I'm going to push back a little bit. Right, on that. Because the petite policy specifically says it does not apply where the state conduct is only a minor part, an insignificant part of the entire course of conduct, and they give examples about where you have some type of a RICO scheme, and the state has indicated or convicted the perpetrator based on something that could be one single overt act in the government's conspiracy, and doesn't that really show what is going on here? That what the state has done was really just a small minor part of the scheme, that the federal government had a real opportunity to punish him for this entire course of conduct? So previously, but if I can circle back to your question previously, it's interesting that you can characterize this as, he's turning these questions into prostitutes. He's turning these girls into prostitutes, and then I think that's really interesting because in 2019, 13 years afterwards, despite all the changes in the law, there is still some element somewhere that says he's turning these girls into prostitutes, whereas this was a typical trafficking case of the kind that you see in the Ludebacher days when, it was called modern-day slavery. That's a very different fact pattern. But, a girl that's held captive is forced to service multiple men per day, where this is part of an ongoing business arrangement. And so I hear what you're saying, but if here at this table at least some element of that characterization is live, what would it mean in 2006 when these laws are still being developed? And that consideration, rightly or wrongly, was part of this analysis. By redacted. Was it explicitly, in other words, was that aspect of it, the perception that this was perhaps activity in which the victims cooperated, was that part of the... No, let me distinguish. I didn't say the perception that this was activities in which the victims cooperated. And I've gone to before is there at least one juror that might say, look, we've got conflicting victim testimony. Some of them said he did nothing wrong. They all knew each other. They kept going back and taking payment. Is this trafficking, or is this prostitution? I'm not saying that I agree with that, and I don't think prosecutors do.
I'm saying, is there at least a possibility of that? And was that articulated to you by the people you were listening to by Redacted? And so, Redacted? So that certainly was part of the discussions when I talk about the victims issue. Would at least some jurors view it that way, rightly or wrongly? And you recall having those conversations? I recall having not only how would the witnesses stand up in court, but how would jurors view them? And then the second part of that is, as it goes up in the appellate process with respect to the federal nexus. And so I hear you, but, it's sort of one of the factors, and so, by Redacted. And so, yeah. What I'm getting, though, is that there didn't seem like there was a consideration or discussion about, is this 2 years capturing the scope of his conduct, versus, we're just going to tie it to this potential state crime that could have been charged. Fair. And I would say that the 2 years was not meant... So the petite policy has several prongs, and to my recollection, the petite analysis was not based on... And let's not even call it petite analysis. That overstates it. But it was much more of a, is this a manifest injustice, and if the original... And so, you sort of see it in the Exhibit 3. This would not have been brought to the office in the first place if, he had pled to jail time and registration, and rightly or wrongly, that was understood from the very beginning of the case, and was a factor in how the case was viewed. And how do you know that that Redacted wouldn't have been upset with a minimal jail time, even if there was sex registration? So, I can't 12 years later say how we knew that. I can say that my general impression was that this was proceeding at the state, that there were certain charges, and that those charges changed when it went to a grand jury, and then it went from... I think they even changed the ASA involved. Redacted. They did. The witness. I can't speak for certain, but you probably have that from the record, and that when they changed the ASA involved and took it to grand jury, the charges that came back were substantially less. By Redacted. Do you remember the circumstances? Did you know the circumstances under which that ASA was changed? I don't know. All right. By the way, do you remember an occasion in which Redacted came to your office in Miami to press you on what was going to be happening with the federal case? I don't recall. You don't recall, Redacted. Just one more. Redacted. Redacted. Yeah. The witness. Yeah. By Redacted. So before we, leave this, one little thing. So if this case had come into the federal system as apart from the, taking the digression through the, state system, do you think that the 2 years was an appropriate punishment, given the scope of his conduct? I think if it had come into the federal system apart from the whole state, and the petite considerations and all that, we may have ended up in a different place. I viewed the 2 years, to my recollection, as a manifest injustice standard, and not an appropriate punishment standard. Meaning, whether it was manifestly unjust that he got 2 years? No, whether it was... So let me rephrase. No jail time was a manifest injustice. If he had gone to jail for 2 years in the state system and registered, the question of whether it would have come to the office at all, and to my recollection, the consensus was, and Redacted, based on Exhibit 3, agrees with that it would never have come to the office in the first place because we would not view that under petite as manifest injustice. There are any number of cases that are prosecuted around the country where an individual gets a jail time that the federal government may not agree with, but that doesn't mean that the federal government re-prosecutes those cases. The instances where the federal government re-prosecutes a state case are pretty rare, to my knowledge. And so, under the petite standard and the manifest injustice would have been a manifest injustice to have 0 jail time and 0 registration, but if the original charges had remained, that would be a different matter. That does not mean that is the best outcome in the state system. And so, perhaps beating an issue, but let me maybe give an example. One concern that I had was that in the violent crime side, the state brings a case and, there was a deferment, no jail time. The state then brings a second case and there's minimal jail time. Well, now the person has done 3 violent crimes, they have a gun, they go federal, and it's like, please don't do that. Pretty please don't do that. We're going to punish you a little bit, and then all of a sudden in comes the federal government with the big punch to the face, because the federal sentences are so different than the state sentences. And that happens all the time in any number of contexts in Florida. That doesn't mean that all of those cases get re-prosecuted as gun cases in Florida. That means that we understand that the Florida system is different than the federal system. And so the way we looked at least based on my recollection, those 2 years was not... What would he have received if this was a purely federal case? But would this case have been prosecuted by the federal system additionally, if he had received jail time and registration in the state system? And is it fair to say that there's particular concern about
for lack of a better word, federalism, or the petite policy, was that a primary concern of yours versus any of your employees in terms of redacted or redacted? I think it's fair to say that I focus more on the legal side of things, and my team focused more on the trial and how this would play out at trial, and both of them sort of inform the outcome. And are you including this petite policy in your consideration of the legal issues? Yes, yeah. I think those are all tied together. By redacted. So you mentioned victim. But could I, yes. To clarify, I thought we had sufficient to go forward, so it wasn't an ethical violation to proceed. Okay. The victim. You mentioned the victims coming into state court, and you talked about all the victims coming into state court. Do you have any idea what victims formed the basis for the original charge that I do not? He was indicted on. Do you know whether it was one? Was it a felony assault prose of a non-minor? It could have been. It was 3 instances to felonize it. You don't know whether it was one person 3 times? 3 people? I do not. And you don't know whether that person was a minor or not? I do not. Alright. I would assume they were, but I do not. Likewise, do you know who was the victim, or who the victims were who formed the basis for the 796.03 charge, to which Epstein ultimately pled in June of 2008? I did not at the time. I've read various accounts of that, but that's based on matters that I've read and not an independent recollection. And what's your understanding? My understanding is that there is at least some issue in the media over whether the right or the best victims were chosen from the prosecution's perspective. And do you know, was there any indication of who the victims were? Do you know who the victims were who were the subject of the state charges? Which particular names? No, I don't. Right, I'm not asking you. Yeah. Other than names? Yeah. I just want to know if you know who they are or how many they were. I do not. Right. It could be one, right? For the solicitation? It could be one, conceivably. Both the charges could relate to one victim. Right. So those matters were very much part of the negotiation that redacted and to some extent Andy were involved in. I did not. What makes you think that your people were negotiating with which victims will form the basis? Fair point. Okay. Fair point, I withdraw. They may not have. I don't know. I don't know how in the weeds and how much our folks, as a federal system, sort of interacted with the state in terms of what punishment. There's at least some discussion in the media regarding whether the punishment was a function of the victims and registration, and I can't speak to that. Alright. Are you aware, just as a point of interest, that the public record of the proceedings in the state court related to Epstein are utterly silent as to who or how many victims form the basis of the charges to which he pled? No, I was not aware. Okay, so this idea of many victims coming forth in state court and so on is not really in play. Alright, so you have a 2 years it's been now. A 2-year state deal has been announced to the team by Redacted. Yeah. With your knowledge and approval, right? Because he wouldn't do it otherwise, is that right? Fair. Though at least one was surprised. Do you know what drove the timing of the plea offer? In other words, why did it have to be made at that point? I do not. Okay. You know that Redacted submitted his resignation on the 23rd of July. I saw that in the documents. In the documents, and he submitted that to your among other, as well as the, HR people. Why not? Well, then there was a July 31st meeting at which the term sheet was presented. The document 15 is the term sheet that was presented, as Redacted indicates in her September 6th cover email, and you said you approved it. You happened to be copied. Right, through. So, Redacted. Let me forward this, but let me be accurate. I approve these terms, whether it was the specific term sheet or another document that might have been earlier that looked highly similar to this. My recollection is approving a resolution that had him pleading to certain state counts that had a binding 2-year plus recommendation that provided for 2.55 restitution. Right, but you don't know if it was this sheet of paper. I can't say 12 years after the fact whether it was this specific sheet. Right. Alright, of others. Based on the fact that this was in the email, I think it's safe to assume, but to assume what? To assume that it was this. Oh, but it's possible that there was a slight difference in. Alright. In fact, this same document with a couple of, additional bullets that had to do with the date of entry of the plea, sort of ministerial, is what was prepared by Redacted on or about the 31st, or on before the 31st of July.
And this document, as indicated, here, along with the attached guidelines calculation, is what was provided to the folks who met on the 31st of July. Okay, so on that 31st, it was redacted. Jeffrey left court, redacted Sanchez, and the purpose of the meeting with Sloman, Menschel, Laurie, and redacted, as well as the case agents, was to present the plea offer. And did you get briefed on how that plea offer went? I don't recall being briefed, but in the regular course, I would have been. Alright, and at that meeting, there was an expression of concern by the defense team that Epstein wanted to avoid being incarcerated in the state system because of concerns for his physical safety, and that concern was accommodated to the extent that the U.S. Attorney's Office team agreed to explore federal resolution. How does that square with your decision that a state plea is how this case was going to be? Right, decided. So I think I indicated later that it's a little bit more fluid than a decision here or a decision, that binary situations. My recollection is we were very focused on this man should go to jail and this man should register. The 2-year plea to the state charges seemed reasonable and seemed a way to go. We can agree or disagree. Reasonable not in terms of, was it the most just outcome, but seemed like a disposition that we would agree to. But ultimately, the focus was on getting him to jail, and if that meant exploring a 371, it's at least worth exploring. And so I don't think it was inconsistent, because the focus really was on he needs to go to jail. Okay, in this case, that pushback that resulted, in the agreement to explore a federal plea, was because Epstein was afraid to be in prison. Why would the U.S. Attorney's Office accommodate that? And here we're beginning to talk about a major point of criticism of this whole process and the outcome, and that is that it appeared that the U.S. Attorney's Office was bending over backward to accommodate the concerns of Jeffrey Epstein, and in this case he was uncomfortable going to a federal or state prison, but all child sex predators who go to prison are going to face some, challenges, right? Right. And I remember along the way a heavy push that he be incarcerated at his home under some kind of home confinement, and my reaction to that was no way. Right. And okay, you don't like prison, but that doesn't mean you get to be incarcerated in your house. Which is interesting, because subsequently, And so, because subsequently what? You might as well finish. Well, because that. Subsequently, the way that the state executed the terms of incarceration were not what I would have expected. And so, again, the focus from my perspective is he needs to go to jail. If the team agreed to explore it, the 371 was on the table, to the extent we have been... I'm speculating now. This is not to make the record clear. Thank you. I am speculating, not recalling. I can speculate a 371 with a 2-year Rule 11 that had been discussed based on the contemporaneous record, that's a big word, and so to the extent it had already been discussed, even if it was not the direction we were talking, would it have been unusual for folks in the room to say, well, look, we've discussed that, let's go back. Let's see where it goes. I can't fault, to the extent it had been discussed, I can't fault anyone for saying, let's go back and look at it. I think that's distinguishable, at least from subsequent. Alright. At that point, the defense was given 2 weeks to take it or leave it, and if not, you would indict. And there were several occasions, correct, where that kind of ultimately was made. Did that mean... given all of your concerns about barriers to what you would consider a successful federal prosecution, was that a bluff? No, it was not. It was not. You were at some level at least prepared to approve the presentation of the presentment of, an indictment? We should not have gone forward with these negotiations if we weren't ready to approve. Whether in this form or a different form an indictment, and I say that because it was very much a draft indictment that hadn't been reviewed fully by the chain, but it wasn't a bluff. Well, by this time it had been reviewed, and it had been reviewed and revised, and it had... There had been some efforts to begin revising, it wasn't finalized. Some efforts to begin. Exactly. Right. Okay. Looking at 11A, this is a letter that Redacted drafted to sort of actually respond to a counteroffer by the defense. The counteroffer is represented in Exhibit 10B, which is a letter from Redacted Sanchez, which you don't need to go into detail. Because, as you've already pointed out, essentially it was a home confinement, and very, very soft. Landing counteroffer. In 11A, Redacted tweaks Redacted's letter. You're copied on this, and the date is August 2nd, Thursday, and he knows that he hadn't discussed it in detail with you, but he wanted to... He hoped that tomorrow, Friday the 3rd, he'd have a chance to... And what's notable here is that there's strong language that the office believes that the federal interest would not be vindicated in the absence of a 2-year term of state imprisonment for Mr. Epstein. That offer was not meant as a starting point for negotiation. It is the minimum term of imprisonment that will obviate the need for federal prosecution.
You're on paragraph 2? 1. 1, yes. Oh, 2, yeah. It's the first, right, long paragraph. And then he also states that you in the last paragraph, the U.S. Attorney Acosta has asked me to communicate that the 2-year term of incarceration is non-negotiable. Yes. That's pretty firm. That's a line. It is. In the concrete, that is setting, right? Right. And 11B is the letter as it actually went out the next day. And it's got the same language. It's identical. It has the same language. It is one typo corrected. This is Redacted's last day in the office. Yes. And he's gone after that. Do you think that this was the appropriate timing to extend this offer, or to set this as the minimum offer? Or was it something that you would have liked to have seen more fully developed in negotiations with defense counsel? I'm sorry, I don't understand your question when you say more fully developed. Well, you have 2 years. Would further consideration have led the U.S. Attorney's Office to decide that, well, maybe the 2 years is too much of a giveaway. We should stick with a 5-year federal plea. Yeah, I can't speculate this far after the fact whether waiting an additional time period and further discussion would have changed things. I can tell you how we came up with it, but that's a lot of speculation. Would you say that Redacted was, as the criminal chief, was essentially the driver of the resolution? Right. Presented in this letter? I can't. Again, you're asking me to speak to something from 12 years ago. I can't speak to it. I was aware of the multiple prongs. I approved it. If we had, at some point, your question is if at some point there had been a let's sit down and reconsider meeting, will we have gone in a different direction? Perhaps, but I can't, 12 years after the fact, speculate as to what may have happened if something had happened. Alright. That's just a lot of hypotheticals. Understood. The question, though, is whether Matt Menshaw, who was the author, right, of this, who first raised it, right, with Redacted Sanchez, yes, in an informal discussion, and who presented it to the U.S. Attorney's Office team, was this really his baby? I can't. Approved by you. I don't remember who I talked to about what, and so it wouldn't be fair for me to, I can't single out any one person as having a greater or lesser role. Well, you are not the architect of this, right? You approved it as you've described it. No, I haven't said I wasn't the architect. What I said is I don't recall. Right, I recall approving it. I think what I'm trying to convey is these discussions are much more fluid than I think any one single architect. You've got multiple lawyers. They interact on a daily basis. They talk back and forth. To put it in an OPR context, there's probably not going to be a single author to the report. You're all going to go back and forth, and there might be someone that has... Maybe there is a single author. Who knows? But I think it's difficult to say there's a single person, and ultimately I was US Attorney, and so I approved it, and... To your knowledge, did anyone in that chain of... Right. That 5-person chain or anyone else disagree with this offer? I'm not talking about... To my knowledge. To my knowledge, I think Redacted at some times may have felt uncomfortable, but whether there was explicit disagreement or not, I don't recall. In terms of my management chain, I don't recall any disagreement. That you are aware of. That I was aware of. I recall discussions. So, for example, Redacted might say I might proceed with a 371 with a 2-year cap under Rule 11, but then we move in this other direction, and I don't recall anyone saying, let's take a time out, let's reconsider. Alright. And let me just clarify. I think at various points in this case, and it's hard to sort of single out the timeline. Miss Redacted was supportive, or maybe I wish we were going a different direction, and that sort of went in and out a little bit. On her part, yes. Let me ask you this. Having reached the decision that you approved, right, that this was the offer, and the term sheet, or the terms, having that decision made, would you have expected your line also to frustrate that, or to not abide by that, since it was your decision? No, with a caveat that if at any point someone felt truly uncomfortable, I would expect them to come and talk to me about it. And can you recall any instance in which an author, a line author, came and talked to you about a disposition that he or she was uncomfortable with? Yes, so I'll give you an example. I don't recall who, before you ask me, but there was this author who was new to the office who impressed the hell out of me. I'm sorry, that's not appropriate language, who impressed me significantly. He had inherited a case, and it was a fraud case, and the bigger players had been charged, and he was basically given a lesser player to basically just finish up on, right? It was a done deal. The person was ready to plead to some minor count, no jail time, and he felt uncomfortable with it, and went to his supervisor, and then ultimately came up to me, and I had a discussion with this person about it, and it ended up with my telling him to go back and call the defense counsel and tell them we were dropping the case. Which, for a new author in the office, is pretty gutsy and unusual, but if this person really felt that this lesser player wasn't deserving, then that was the right thing to do. Right. And so, And the person was not punished for it. If anything, I recounted that story to others. Okay. A question. Shifting gears. Yeah. A little bit. About 18 USC 22.55. Yes, okay. Not to be confused with 28 USC 22.55, which every prosecutor is familiar with. So, whose idea was that? It's a civil provision. It's not restitution, it's damages. It's a damages recovery provision in the criminal code. Right. Who came up with that? I can't speak to who came up with it. Okay. I can speak to the reasoning behind it. Your reasoning, or the proponent's reasoning. My recollection of the reasoning as to why we thought it was important. And the importance was to provide a mechanism for recovery of damages. Yeah. Okay. Yeah, I mean, the victim's bad situation, and here it is. Well, go on. Alright. I might circle back on something. So, is it fair to say that's a fairly... Had you ever heard of it before? Had you come across it before? I don't know, but I don't think so. Okay. So, is it fair to say it was novel to the office, to you, and to this team? I don't think it's fair to say that it's novel to the office. Well, do you recall whether anybody in the team had experience with 18 USC 22.55 in a criminal? I don't have a recollection of any discussion as to whether people had experience with this or not. Did you believe that any legal research was needed or should be undertaken to ensure that the procedure was in fact legally sound when embedded, as it was in this case in the criminal plea? So I would have expected to the extent that there were concerns. Again, we had incredibly experienced. Between the various individuals in my management team, we probably had 50 years plus of criminal experience. I would have expected to the extent there are concerns for those concerns to be raised. Did you raise any such concerns about it, or did it seem to make sense to you? From my perspective, I recall... I don't know if it was at the time or subsequent to it, reading it, and it seemed to make sense. Okay. After a redacted letter went out on the 3rd of August, you almost immediately... It appears you received a telephone call from Kirkland and Ellis, is that correct? I don't recall it independently, but that's what the record shows. Alright, and that's reflected in Exhibit 12. Do you remember who called you? I do not. Do you recall... It apparently was from the context of this Exhibit 12, and the caption Epstein. Right. It appears that the call related to Epstein, correct? Correct. Again, I don't remember the phone call, but from the email I accepted that it happened. So, what had been your knowledge and relationship with Ken Starr of Kirkland and Ellis? Right, up to this point. So, I had been an associate at Kirkland, I think I indicated. What was it? From 94 to 90. What was it? Was it 96 or 97? For a couple of years. I worked on at least one case that I recalled with him. I was the junior associate on a merits brief that he argued. He, at the time, was also special counsel. And so he wasn't in the office nearly as much because he was double-hatting as special counsel. And partner. Alright. And what about Redacted? So, Redacted was a partner at the time. I don't recall working with him on any particular case, although I think I worked with him on at least a matter. He was on my hallway. He had an outside office. I had the typical inside office. Had you had any interaction, any contact with them in the intervening years, socially or professionally? On and off. I was in Washington. Ken Starr was in Washington. I think Redacted had moved to New York, but then came back to Washington to be in the administration. And he was in the policy office, and we likely interacted. And while you were here at the Civil Rights Division, correct. Alright. And were you friends? Were you professional acquaintances? Were you what? How would you characterize that? We were professional acquaintances that had worked together several years ago that continue to interact. Is that true as to the two of them? I mean, it's hard to characterize these things. I think that's fair to say. Did Ken Starr know who you were? Yes. And obviously Redacted as well. Yes. Okay. So what was your reaction to being contacted by them by their firm, them, presumably one of... Right. Them perhaps? So I don't know who called based on the email. I can infer that it was one of them. And I think my reaction is captured by, not my email, but by Jeff's comment, and what, I don't have a clear recollection, but I'm going to speculate or infer, that I heard they were being brought onto the case, and I probably walked down to Jeff's office and said, hey, Kirkland's coming onto the case, I bet you they're going to come on to try and take this up to DC. And then I get a phone call, and then I tell Matt, who tells Jeff, I didn't know, maybe Kirkland made a call to... You're right, unbelievable. And then I say they're likely to go to DC. We should strategize a bit. My concerns behind that are,
will DC look at this as sort of legally troubled, going back to the earlier points that I made about the policy issue around the trafficking issues up here in DC. And I really do think he should go to jail, and so I want to strategize a bit. So, did you have concern about the fact that that the defense team was sort of appealing you to the big house? I think based on this, I almost predicted this would happen. Yeah. And Jeff is saying you were right. Unbelievable. Where I, in some way, shape, or form, predicted that someone would be hired, or something would happen to take this all up to DC. And had you experienced other instances in which defense team went to DC while you were at U.S. Attorney's office, while you were the U.S. Attorney? Yes. Was that a concern to you? It wasn't a concern, it was a, how do we address this so that we can back our position in our office? Did you have concerns about the disposition that was underway? About main justice scrutiny of the MPA scheme? So, I had no concerns about main justice scrutiny of the MPA scheme. In fact, I invited Drew to come down. Right. And he was part of the meeting where we discussed the MPA. And so, I say that because if I had concerns, I wouldn't have invited him. If anything, my concern was, is main justice on board? Or are we going to basically be told to drop this case when it goes up to main justice? In your email to Redacted, when Sloman's on vacation, you say that you make reference to a process foul, that the attorneys in the defense team want to go to DC on the case of the grounds of a process foul, i.e. that I have not met with them, and you express concern that that would delay matters. Is that what led you to agree to meet with the defense team on the 7th of September? It is. My concern was, they came out to DC, and the first talking about, well, the US attorney didn't even agree to meet with us. That's not the best. That's not the best foot to start with when you're having your case reviewed. So, what was your understanding of what the purpose of the meeting on September 7th was supposed to be? They wanted to argue, being defense counsel, wanted to argue why we should not pursue this case. And in this case, it was Starr and Lefkowitz from Kirkland & Ellis and Liliane Sanchez, I believe, who met with you. Fair. I remember it was Starr and Lefkowitz. I don't know if it was Lily Allen. Oh. Alright. And our information is, it was you, Drew Oosterbaum, Sloman, Redacted, and John McMillan. Do you know John McMillan? Vaguely. Alright, he was an author as well. Right. Correct. In West Palm? Right, and if I could just add, again, I invited Drew. So, Drew became fully aware of that, and my concern in getting Drew into the meeting was to not have them appeal us, and then have Drew say, not a good case. Alright. So, were you aware that Drew Oosterbaum had, in preparation for this, gone to West Palm and actually gone through the evidence and met with the case agent and the line officer? I was not. Drew is an independent actor and could do what he thought appropriate. Does that seem like an appropriate thing for him to have done in your eyes? Sure. Okay. Would you describe the meeting? Oh, and two other people who were there were, again, ASAC Val Parlave and Junior Ortiz. Right. The SSA. So, and the meeting I think was in West Palm Beach. Yes. So what do you recall about the meeting? The dynamics? Who spoke? How did it go down? I recall there was a lot of people. I think Mr. Saar spoke most of the time. I think my recollection, as best as I can, with the caveat I thought Redacted was there, and clearly he wasn't, so presented several arguments. I then either left the room with my team, or I think I most likely asked them to leave the room. I then went around and asked who to leave the room. Asked the defense? Defense. I then went around the table and I said, does anyone have any concerns or something to that effect? And then hearing none, I asked them to come back in and I reaffirmed the position of the office. In other words, you sort of decided, you ruled from the bench, as it were. Fair enough? Fair enough. Okay. You didn't take it under advisement. You gave them what your position was right then and there. That's my recollection. I don't know if you have information contrary, but at least, okay. That's my recollection. Okay. So, is it fair to say it was more of a presentation on the part of Ken Starr and his side, rather than a debate or discussion? I think that's fair to say. I may have asked a question or two, but my recollection was not a negotiation, but a let's hear you out. And so we understand it was mainly a federalism presentation, as opposed to evidence. Is that accurate? I believe that's accurate, yes. And in your letter to Ken Starr, dated... The letter is actually not dated, but we know that it was sent on the 4th of December. Okay. Of 2007, and it's in this package. You noted that... Which exhibit? Mr. Gonzalez. 34. By Redacted. Thank you. Exhibit 34. You note on page 4,
I'm sorry, page 5, you refer to the federalism arguments, and you say that after considering the arguments and conferring with the FBI and True Oosterbahn, you decided to proceed with the indictment, but that you would delay presentation of the indictment to allow the defense to appeal to DC. Does that mean you didn't find the federalism arguments sufficiently persuasive to you to change your position? Yes, with a position defined as some concern. But if we need to, if we don't come to a resolution based on the sheet, then we indict. And there was a letter of... by redacted.
I'm sorry, when you say some concern about the federalism argument?
Yeah, going back to what we talked about with respect to the earlier conversation about solicitation versus trafficking and the federal nexus. But back in July, we had decided that we were going forward, that either there is a pre-indictment resolution, or we go forward with an indictment. The September meeting did not alter or shift our position. By redacted. Even though you had some federalism concerns of your own, they didn't rise to a sufficiently high level. So their request was to drop the matter. Right. And okay. Going back again. Understood. There is legal risk. There is witness risk. All of these. If we can get pre-indictment resolution, good. If not, the indictment was not a bluff. It was real. Ken Starr is of course well known. Right. He was Solicitor General. He's, etc. Did you find his arguments well set forth? Impressive? So, you're asking for something that's 12 years... If I had to characterize, by the time this meeting took place, there had been a fair amount of thought around these. There had been a fair amount of... And I at least felt comfortable that while there was some legal risk, we needed... You've got to balance the legal risk and the precedent risk with outcomes. And Mr. Epstein should go to jail and should register, and I felt comfortable. I felt comfortable enough to basically reiterate our position that... But my question with respect to, right, was, did you enjoy the give and take with a man of Mr. Starr's, in all candor?
No.
Standing?
No.
No? Not at all? Not at all, because, alright. It would have been easier to not have the meeting in the first place. Alright. Do you recall an exchange? Were you the person to whom he was directing most of his comments? Most likely. And do you recall any exchange with him about the fact that sort of an observation that the two of you and he, were the only two people in the room who had been presidentially nominated and Senate confirmed to any position, so that the two of you had kind of that commonality. Does that ring, do you mean, a bell? Was he trying to butter me up? Was he? Was he? Look, this was 12 years ago. I don't recall. I think as we talk about this, it's important to note that the position did not change. Whatever exchange they may have had, our position did not change. Right. After this meeting, within a few days, in furtherance of the resolution that had been offered, redacted Laurie met with the state attorney's office to sit down and try to work out how this thing would work. And mind you, this was before the MPA is, actually formulated. Did you learn what happened at that meeting? Do you know how it devolved? I may have. I don't recall, sitting here today. Alright. Is at this meeting that somehow, the three charges that you specified, your office specified in the term sheet became one. So suddenly Epstein was to plead only to one charge, and this was agreed to by the US Attorney's Office folks who were there. Do you know how or why that happened? I haven't the slightest idea. If you had known, if they had called you on the phone, sort of the mid-trial, right, called to the boss, asking what you wanted them to do, what would you have said? So from my perspective, when I said, when I indicated I approved this term sheet, this is the minimum, I meant what I said. I also recognize that ORSAs in the usual course need some degree of discretion to negotiate, and so my assumption after that September meeting, I think I indicated that there was a deadline, that was fairly short, was that redacted, and some, working together, would go back and work out an agreement based on those terms. And, in the give and take, if they think that this is an important concession, that's within their discretion, but I would have been comfortable sticking to that. With charge sheet. With something that drove me is when I said something, as a general matter, I didn't bluff. I really meant what I said. So in that term sheet, to be fair, what Menschel's letter says is 2 years, right, is the minimum. If the decision to agree to let him plead to one, as opposed to all three, had no impact on that 2 years, would you have cared? Fair enough. And so going back to where to an earlier discussion, can I get another Red Bull? Going back to earlier discussion, I think I indicated that the state charges I wasn't familiar with. And so, if in the give and take those charges changed, my focus was on 2-year registration and restitution, as long as those charges were captured the conduct in some appropriate way. So later, rather much later, the defense counsel admitted that at this meeting they thought, yes, that under misinformation from the state attorney's office, that charge that they got the U.S. attorney's office, or somehow the U.S. attorney's office approved, the 796.03 charge was not sex offender registrable, and that's a pretty major mistake, right? It is, and I mean that goes to the heart of one of your major concerns. And they tried to get us to change that, and I said no. The defense tried to get you off sex offender registration. Pretty vigorously. Right? But at this point, the focus is on the charge, and the defense is, one might characterize it as trying to pull a fast one by agreeing wholeheartedly to plead to one charge, knowing, or at least believing incorrectly, that it was not registrable, and the U.S. Attorney's Office not having that belief, but thinking it was registrable. So there's a disconnect. There is error. And the error stems, as they later learned, from the ASA herself. So we look at that, and wonder whether that shouldn't have raised some concern that this plan to put things back in the hands of the state, which had kind of mishandled the case to begin with, as, at this point, even not a good idea, because they were continuing to be, well, I won't characterize it, but less than reliable. Is that a fair comment of concern? So one question I would have is, at what point did we become aware that there have been... First, the error was in our favour, not the defence's favour, because Redacted got it right, as opposed to the ASA. Correct. And secondly, at what point did our team become aware of them trying to pull a fast one? Was it before or after the signing of the MPA? It was well after, right. But the point here is that the US Attorney's Office folks were not as familiar with the state procedure, the state criminal procedure, and the ins and outs of the sentencing and incarceration, as you learn later. So, didn't this put the US Attorney's Office side at a substantial disadvantage in trying to play in the sandbox in which both the defense, local defense counsel, and the SAs were very comfortable? Possibly, although I will point out that it was the ORSA who got it right. Not eventually, the ORSA, was correct in her analysis. Right. So, in this case, she was more familiar than the state attorney. Not by practice, but by research, and so, right. My point is, we had good people that were able to, if they weren't familiar with something, the research clearly worked. But it took, as you saw in the process of dealing with the work release and all of that, it took a lot of work to keep up with those. It did. Errors. Which is why I say in hindsight, if, given all the effort that took place after this defer to the state was reached, if all that had been known, I really think the analysis would have proceeded differently. Because that was what was a lot of work. That was probably as much work, if not more, than a trial. Right. Meanwhile, we'll talk about the actual text of the MPA in a moment, but following that... Actually, no, before it was finalized, Redacted was working to identify a federal charge, as we discussed before. In that process, she came up with a plan that would have resulted cobbling things together in an 18-month sentence instead of, 24 months. Somehow that became the new floor. The new standard. Do you know how that came about, and who actually agreed to that? I don't. I referenced the one email where I think Redacted says he argued 12. Right. I said 24. We agreed to 18. I assume in the give and take, this was an argument that was reached as... But that was 18 as to the potential federal charges. It somehow became imported, into the state disposition. I can't speak to that. This was something that the trial team was negotiating, and from my perspective, these were the terms that we wanted. These were the terms that I expected if they came back and said no deal. Disappointed, but go forward. But they tried to get a deal, and the defense tried? No, but our prosecutors. And to some extent, they... And the give and take of any negotiation, I don't think it's unfair for an ORSA to give up some things. But has stated clearly to not only the defense team for the mention letter, but also, I believe, at the end of the December 7th meeting, that 2 years was the deal. So, did somebody come to you and say, looks like it's going to be 18 months, and allow you to then approve that? I don't recall if someone came to me separately or independently of the final language. I clearly approved it at some point. And so, to the extent it was approved, that's on me. But I would argue that, someone's negotiating, one says 24, another side says 12.
they say, let's agree to 18. To some extent, as U.S. Attorney, I think I have to back the negotiating discretion of my authors. But you explained quite eloquently the reasoning for the 2-year plea as being what Epstein would have faced if he'd been prosecuted. Right. Absentia by the state appropriately. And then suddenly, without any apparent relationship to that analysis, the 18 months pops up from an effort to try to get federal charges. And so how does that not undercut the basis for the 2 years? So I can provide the reasoning for the 2 years. I also, though, think that as a supervisor, as U.S. Attorney, it's important to understand that when individuals go out into the field, negotiations take place. And if every time there is some give, they need to come back to the U.S. Attorney, or there is a fear that the U.S. Attorney will not back us. There's a certain... I think there's a management issue there, in that if an author speaking on behalf of the US makes an agreement, as long as that agreement is within a certain range, the US Attorney should back that, because they're the ones that are on the line. They're the ones that are managing the case, and it's sort of unfair to consistently second-guess those late night... I don't want to characterize it. Okay, I say late night negotiation, but that give and take that happens sometimes in a conference room or on the phone. Do you know exactly what give and take occurred in this case regarding the 18 months? I do not. I've read that one document. Okay, but I do not. Alright. Any other questions on this one? By redacted.
Really quick. I agree with what you're saying in principle, but in this case you had almost like a mandatory 2 years is the minimum that the U.S. Attorney will accept. Under those circumstances, where you have come out and said, this is the minimum we'll accept, would you have expected them to have to come back to you to get approval for any kind of reduction in that amount? Would I have expected them? I think Ms. Redacted was in a tough position because opposing counsel was coming at her. It was a tough negotiation. Would I have wanted 2 years? Yes. Would I falter for agreeing to 18 months? I don't think that's fair to her. By Redacted. You could have said no, right?
I could have. But she had agreed to it. The process had gone further down, and to some extent I think there was a need to respect that process. That happens. I guess I was getting, this is not the only case where a supervisor sort of says, this is our standard, and at some point things move, and you've got to provide some discretion. Alright. By Redacted. Do you think she misunderstood the priorities? That she thought you wanted to get to a resolution, and so the 2 years could be undercut, versus taking your words literally, and saying this is the line in the sand beyond which you should not go, even if it means kill this resolution? So if I had to speculate, I don't think it was a misunderstanding of priorities, as opposed to opposing counsel was exhausting. And if you go for the full record, it really wasn't exhausting. Opposing counsel in this case was very good at taking any slight millimeter and turning it into, oh, so you said we could do this, and in that back and forth, sometimes there is a, can't we just agree in the middle? And I understand what you're saying, but weren't they exhausting because the US Attorney's Office would not say no to them? And so they always believe from the get-go, because they have a 2-year minimum, that the office is willing to then say, oh, we can go down from there, and that they set the tone from then on, that they could continually chip away at you on virtually every single term that came about. So yes, they were exhausting, but isn't that because the US Attorney's Office would not tell them no? So I would push back, because after the agreement was signed, I would argue they did not chip away. They certainly kept appealing collaterally. And we can talk about that, because there were other concerns raised there. But once we had that September meeting, between that September meeting and the signing of the defendant in favour of the state, that was all negotiated by the trial team. That wasn't a come back to the US Attorney or come to the first assistant. That really, to my recollection, was go negotiate with the state, with the line. Well, but there were a number of things that came about later on. I mean, they continually griped about the 22.55, and that got modified. Later on, and I think later ons are different for some reason we can talk about now or later, but there was an attempt to work this out later on that was clearly there. Redacted. The witness. But I think that's very different than how was the agreement negotiated? And I think that's a very different sort of timeline. By Redacted. So in your mind, was she prepared to walk away from the deal if need be? After it was signed? Before it was signed. Before it was signed, it honestly was. Get a deal, or ultimately, if we have to indict, we indict. And that's what I said, and I look at it this way. After having said that, if that really was a bluff, what would I look like, right? I would look awful. And so for that reason, that was not a bluff. That was a thought through. This is what we will do. Yeah, this is what we'll do. And if you don't agree to this, then we indict, and we indict.
You can't make this kind of statements and not follow through. The office loses credibility if you do. Right, but you can keep giving on certain terms. And my point is we did not give, with the exception of that 24 to 18, we did not give. By redacted. Well, you also gave up 2 charges. Again, I'm thinking of a 2 years registration, restitution, and so with the exception of that 24 to 18, we did not give. I want to go back. This morning we were talking about our tracks, and we talked about the legal track, and a little bit about the evidence track. There's another aspect of the evidence track that is in play here, because there was a substantial type of evidence, and the question is, to what extent were you aware of this? In October of 2005, the local police executed a search warrant on Epstein's residence, and among things they found, there were cables and cores where there had been computers, computer equipment, video surveillance, cameras and CPUs, all of that, they're computer-based stuff. It had been removed, forgetting why necessarily. If you look at Exhibit 29, were you aware of that, by the way? That had occurred? I was aware that the state had gathered evidence, but not much more. Beyond that. Okay, so 29 is... I'm sorry, I'm on 21. Wait a minute, this is not the one I'm looking for. 73? Let's do... Do you know what? Okay, this is not the exhibit I'm looking for, and the numbers are a little bit messed up. There is an email, which I may or may not be able to put my hands on, in which Redacted informs you that she really wants to get her hands on important potential. On computer evidence. That it's important potential evidence, and she had a plan to get it. So the question is whether you knew at the time that the investigators had identified this computer evidence as being out there, and that they believed it contained a potentially very significant evidence against Epstein. Computers, surveillance cameras, given his activity, right, in his home. Redacted. He's not on it. By redacted. Alright, she did not inform you. She informed someone else She informed Sloman and Menschel on July 3rd, and Laurie. My apologies, you're not on this. When she advises them that we want to get the computer equipment that was removed from Epstein's home prior to the state search warrant as soon as possible. So there was the stuff out there, and, right. As of July, there was an abiding keen interest in getting it, and the defense team was resisting the prosecutor's efforts to get it. Were you aware of that at all? I think you asked about that in your questions to me. Right, I did. I have no recollection of this computer evidence that... Alright. Did the question say that, without getting into specifics, that there was a grand jury issue around this? It does. I don't have that. It is addressed in the non-prosecution agreement if you look at the final non-pros... Yeah, I don't have. It's referred to, I should say. It's referred to. The question that you asked, what question was that? Hello, Dexter, you alright? The question was whether you were aware that that was something that the prosecutors wanted to get. I don't have a recollection of some computer evidence. Alright, but I think... Is there? What was the question? Aware that Redacted was instructed by her managers to delay her efforts to get this computer evidence because the defense were resisting those efforts, and it became an issue that was in play in the negotiations. I have no recollection of that. Okay, if you can give me 1 second. Sure. Pending federal... And so your question said that there was litigation pending in federal court related to the U.S. Attorney's efforts to obtain, computer evidence? Without going into further detail, I have no recollection of any litigation pending in federal court regarding that. Alright. And did anyone suggest to you and your team that getting to a plea deal was premature because you needed to get this evidence first so that you knew whether you had potentially some very important evidence against Epstein? I have no recollection, and if anything, okay. I think there was a desire to move quickly as opposed to slowly. On the plea? Yes. And do you know where that energy came from? Who was wanting to... I don't, but move quickly? As I recall, so for example, when we were setting up the meeting in September, there was a request to set it up in August as opposed to September, and we had to push it back to September because of vacations or something. Alright. So in addition to not getting the computer evidence, the government curtailed the investigation to a large extent, despite finding more victims. There were witnesses who were not interviewed, things that were not searched, property that wasn't searched, target letters not served. So these all would have been steps taken by the FBI to enhance the federal investigation, right? As opposed to back to the state, right? In case that this was sort of, being returned to, right? Was this... Mr. Todd, are you asking Alex if he's aware of all the things you just said? By redacted. Were you aware of all of those steps that were being foregone? Or foreclosed? No. My assumption would have been we may have to go to trial, and so we should continue to develop the basis for trial. So if I could, for example, after Drew came down, I said, if we go to trial, can you be on the trial team? I cite that because I'm thinking we may have to go to trial. Right. Why not get Drew, who's from Miami, on the trial team? So is it your understanding that the federal investigation, notwithstanding the drafting of this MPA, was still continuing? Yes, my understanding is you run these on parallel tracks, and again, I'm sitting here inviting the head of CEOS to be part of the trial team, and talking about how to formulate the trial team. Okay, that implies that I was clearly thinking we might be going to trial. Alright. When you first received the draft of the non-pros agreement, and this is 16A, it's a draft by Redacted. Do you know who came up with the... It sounds like you didn't, but who came up with the name or the moniker non-prosecution agreement? I do not. Do you know what this was modelled on, if anything? What the genesis was? I do not. I noticed from the contemporaneous emails that initially it was done differently, and I think it was Redacted Laurie who said write it as a contract, or I think there was an email to that effect. Someone may recall it better than I, but this version of September 10th, which is the first business day after that, September 7th meeting from Redacted goes to a management up through you, and you do a rewrite almost right away, adding original state charges, which at that point were all still in play, and you also added, this is Exhibit 16B, a statement that it would be Epstein's job to move the state to add additional charges, and that latter piece is on page 3, just below paragraph 8, so you were... Can I back up a second? Sure. When you say I did a rewrite, is there some indication of what I did a rewrite of? Yes, if you compare the two... Right. There are things that are bracketed in yellow in Exhibit 16B, which represent... Right. The changes from 16A. Right. Okay. So those are the two things that are different, and they're referenced in your message. Yeah, at the beginning. We bracketed them just to make it easier for you to recognize, right, that. So my point is that right from the beginning, you are participating in the process, in the drafting process. Oh, so I would characterize that as not participating in the drafting process, but approving a draft. I did a small difference. Rewrite. Yeah, and so something comes... Here's how I would distinguish. Someone that's participating in the drafting process is sitting at the table with 2 or 3 people, drafting it as they go, versus something goes through the management chain, and someone in the supervisory train says, can you change A, B, or C? Alright. I clearly, here and in other places, it looks like I'm inserting the same themes, which is deferring to the state. Let's mention the state charges. And we can't force the state to do anything, and so I'm adding to this. I'm clearly aware of it and approving it, but I wouldn't say that I was drafting. Fair enough. Did you read it? I would assume that I read it, or else I wouldn't have edited it. Alright. So we have a draft from Redacted. A working draft on September 10th, with a small rewrite from you. There is in the Exhibit 17 series indication that of the kind of activity that Redacted was going through to come up with a federal plea, but eventually she and the defense attorney, who is most actively working on this, J. Lefkowitz, turn back to the MPA, and if you look at 17D, just to make the sort of starting clear, of course, Redacted has left. Redacted is going on vacation as of September 15th, and so Redacted Laurie has helped finalize. So the finalizing of the MPA, the final version of which is in Exhibit 22, falls to Redacted with Redacted, right? Yes. Okay. And Redacted puts you on notice in 18B in that process. This email in 18B is sort of a follow-on to 18A. Do you see it comes 1 minute after your email in 18A? It's a response from her to you, only in which she makes note that the defense tried to reopen all the loopholes that I had sewn shut. Yes. So it's fair to say that you're on notice that they're being difficult. That's fair. Okay. In the course of that being difficult, 19A is an email to you from Redacted on September 18th in which she represents that, or explains that the defense is that things are kind of falling apart with the negotiations, and she fears the deal is going to fall apart completely. Mr. Todd, should we take a quick break here? You're losing your voice. I can confirm. Redacted, I'm fine. Mr. Todd, you could probably use a minute. Redacted, alright, we'll take a break. The witness, alright. Redacted, a 4-minute break. Mr. Todd, 4 minutes, that's... Redacted, okay, off the record. My voice is going a little bit as well, but that's fine. I mean, I reckon I've been making steady progress on this. Still got the energy to keep going. But I don't want to knacker my voice out for tomorrow, because tomorrow I record wearing power armor to a magic school. And, yeah, that's a fan favorite. I can't fuck that up. Hey, Dex. He's a good boy. Oh, they've been so good. Oh, no. That's my whiskey. Now, you can't stick your nose in that. You won't like that. He's a good boy. Such a good boy. So, I started this stream at 8 o'clock. I think I mightn't try doing this going forward, but obviously my day-to-day recording has priority. Monday and Tuesday this week were a little bit difficult, so that's why I wasn't recording. Dexter, where are you going? Aww. He's lying just below my mic. That's fine. He's a good boy. It's alright, you child there. By redacted. Back on the record, looking at Exhibit 19C, you say, "You're right to redact it regarding whether you're available to, at a time when she's going to be hashing out language. You advise her that, but I don't think I should be part of negotiations. I'd rather leave that to you, if that's okay." Yes. Why did you say that to her? Because she was the line lawyer involved, and I think it's important for a US attorney to, absent truly exceptional circumstances, to not get involved in sort of the negotiations. You can meet, like I did in September, reaffirm the position of the office, back your author, but ultimately, I think your trial lawyer needs discretion to do their job. At this point, of course we know Redacted is on vacation, right? And you're aware, were you not, that Redacted Laurie was about to decamp for Washington. In other words, he left at the end of September, yes, to become the Chief of Staff and Principal Deputy Assistant Attorney General. Correct. For Redacted, yes. Who headed the criminal division. Okay, so it was really just the two of them at this point, and with nobody apparently involved between them and you. So, fair. But when you say just the two of them, Redacted is an incredibly experienced lawyer. So to say just the two of them is should not imply that there was an experience in that table. I certainly in no way intend to. Right. Too fair. Suggest that. Fair enough. Looking at 19D, in which Redacted is on page 2, looking at the latest draft from Redacted, meaning Redacted, and this is in the throes of negotiating the MPA. Redacted is essentially telling you he agrees with Redacted's observations that the defense team are just up to all kinds of nonsense in this deal, and constantly changing their terms, and not just apparently negotiating or dealing with these warring drafts with the drafting process in good faith. Again, that's my characterization, but Redacted says to you in this email, I suggest we simply tell him, Redacted, that his counteroffer is rejected, and that we intend to move forward with our case. Right? And then your response is interesting. You say to him, why don't we just call him? Tell him, 1, you agree and then change things. 2, you being Redacted agrees and changes things. Correct. Tell him you agree, meaning Redacted agrees? No, I see. Yeah. Tell him you, Redacted, agree and you change things. I see. That is not acceptable to us and is in bad faith. Stop it, or just indict and then try to work it out. So, is to try to work it out. If numbers 1 and 2 are what you should tell, what Redacted should tell Redacted, is number 3 something Redacted should tell Redacted, or what you're telling Redacted? Try to work it out. It's what I'm telling Redacted. Okay. So just to be clear, you say tell him, meaning you, Redacted, tell J, number 1. So, and number 2, but number 3 is then what you're instructing Redacted to do. Yes. I'm just trying to understand. Yes, so, okay. So my understanding of this is they're being difficult. Hey, this isn't the first time that an attorney agrees to something and then goes back and tries to pull a fast one. So tell him you're onto this, that they need to stop it or will indict, but then that will try to, Redacted should try to work it out. Okay, but they need to stop this tactic. Did you really think that was going to be effective with this defense? I don't know. Team? I think one of the hard things with this is, if it was right on September 6th, it remained right, irrespective of really. I think I say, sorry, I know it's a pain. You do. This negotiation was a pain. But if it was the right position, the fact that you've got annoying counsel on the other side, doesn't it make it any less of a right position? You tell them stop being annoying, you try to work it out, and if not, then you indict. Alright, and is that sort of... You had a question? Redacted. I was going to, but Redacted was going ahead. By Redacted. Is that being consistent with your sort of way of doing business? Being even and working it out? Yeah, that is our position. It's not a bluff, it's what we want. You work it out. People yell and scream on the other side. You work it out. If not, then we indict. What would have been the tipping point for you? What would have caused you to say, okay, I agree with you, redacted, I agree with you, redacted, let's indict? So it's really difficult to speculate, but I think the tipping point would have been a failure to reach, it was pretty clear, jail time, registration, restitution. Okay, we moved from 24 to 18 months. That was a give and take, but ultimately, if they came back and said we can't agree to these terms, then we indict. Alright. By redacted. It seemed like your troops are telling you we've reached the end of our rope. We really want to just go forward and indict. Right. And you were coming back with, tell them again that the defense is being difficult, but I want you to work it out. Does that tell your troops basically that what your priority is? You want them to get to this resolution, and if they have to give up stuff, it's okay. It's really okay, but you want this resolution. So, it's not if you have to give up stuff. I'm not telling them to give up stuff. I'm not telling them to negotiate things away, but I think the dynamic from my perspective is incredibly... So there's a tactic that council will sometimes take when they negotiate, and then they try to come back and renegotiate, and that is, to my thinking, one of the most annoying tactics that you can have, and it creates a lot of frustration. And what I'm trying to say is, look, they might be frustrating folks, but if this has been worked out, so looking at this, we thought we had an agreement, and then they changed things, and I'm saying, look, if you thought you had an agreement, tell them you had an agreement. Don't let them change things. I understand it's frustrating to you, but if it was right 2 weeks ago, the fact that they are frustrating attorneys doesn't change the underlying legal analysis. The attorney's behavior doesn't inform the rightness of a wrongness of a certain disposition to a point. By redacted. What's the point? So I think after now I'm calling it an MPA, I was personally very frustrated with the failure to report on October 20th, and I had envisioned that entire collateral attack. I think I would have looked at this very differently. In what respect? To the extent that this was going back to, for example, the public corruption prosecutions that we had. One of the values of it was to have a public figure stand up and say, I did this, and plead. One of the values was avoiding a long and messy legal process. And so when you put all of that together, this is why I say it's not quite. This was the factor that we consider. That is, all of this put together, and in something that could have been very positive for the victims over sending a signal, as it dragged on, became exhausting and negative for the victims. It put us in a position of what to do with notifications. It put us in the position of a lot of appeals to Washington. It put us in the position of having to deal with complicated legal issues that actually got more messy in terms of how does a federal 22.55 relate to a state charge. And had all of that been known, I do think this would have proceeded differently. Differently in what way? So if I factored all of that, I can't predict it's right, what I would have done. But I think if I had known all of that, this could have proceeded very differently. I was very frustrated with the October to June time period. So if you had been back in that time frame in early September, looking at this with, I don't know, what Harry Potter character it is, right, but whoever can see into the future and anticipated or foresaw, right, what would have happened? Would you have simply said, look, we're not going to go the state route or go the federal route? Quite possibly. All right. And let me we'll probably get into it, but at some point, I do think the post versus the pre-signature time period was different for any number of reasons, and we'll probably want to talk about that. All right, we will. But now I'd like to return to some of the terms of the MPA, because you did make... Let me make sure that this is correct.
Redacted. You skipped this one.
By redacted. Oh yeah, before that. Thank you. My colleague reminds me 19E is an exhibit that has an exchange between you and redacted Laurie about at the time when the federal plea agreement, right, was still in play, and the issue is whether you should sign it, and, right, you didn't want to because you never do. But you say at the bottom we should only go forward if the trial team supports and signs this agreement. What did you mean by that? The first part of it? So what I meant by that was I got something that the document was unusual. So my signature appearing on this document is not in and of itself unusual. And this would have been the plea agreement, not the federal plea agreement, or was this about the MPA? This was about the MPA. Okay. Right, and so the MPA had my signature. Now, the MPA is almost too generous. So that in and of itself is not indicative of something, but it does raise my concern. Is this something that ultimately the trial team does not feel comfortable with? And if it's something they don't feel comfortable with, should they speak up and let me know, because we shouldn't go forward with it? And did you ever have a conversation or a discussion about that issue, other than mentioning it? Not my recollection. I would... Okay. Assume based on this that Redacted would read it and would take me at my word and say, look, I think you're going in the wrong direction, Alex. I think you're going in the wrong direction, or I'm uncomfortable with it. Okay, all right. By Redacted.
Did you ever have a direct conversation with Redacted about wanting her to sign the agreement, as opposed to yourself?
I did not.
this was my communications with Redacted, and I really meant that if at the end of the day my team isn't comfortable, then you shouldn't go forward. You never recall hearing from Redacted that she was not comfortable moving forward with the plea agreement? By Redacted, the MPA? I did not hear. I don't recall hearing from Redacted that she was not comfortable. I know that at various points she became frustrated. At various points Redacted became frustrated, but they were negotiating this. If at some point they did not, they thought this was a mistake, or wrong, or unjust, I would think that they would tell me. What would you have done? Sit down and really have a serious conversation about where this is going, and sit down and hear them out, again, even if at this late phase. Right. I would think that that's what I would have done. Alright, let's turn to the MPA. What is this? Exhibit 22? Did you read it? We know that you made some final tweaks to it. 22. So, it's the final, as signed, 22. And so I would... Again, I don't have an independent recollection of reading it. I would not have made tweaks to it without reading it. Okay, and so I think you can infer that I read it. Alright, and let me say you were clerk to an appellate, a very eminent appellate judge, and you did you do appellate work? I did. Yourself? So you were somebody who's an appellate lawyer, who has that experience at a high level, is often more sensitive to words and phrasings, and to documents, contents, that might be, again, to caricaturize a little bit, but a more of a shoot-from-the-hip trial attorney who spends his days, in a rough-and-tumble courtroom. And is it fair to say that you were more of the former, and more... So I would push back. I think that's not respecting the talent of the trial lawyer. And particularly on these types of agreements or documents, these are folks that sort of have expertise, because even if this was sui generis, they have seen a lot of this. I am not suggesting that Redacted and Redacted Laurie. Right. We're not up to this. Right. Because certainly she also had a lot of appellate experience. I'm simply noting that this seems to be sort of in your wheelhouse. Well, look, I apologize. I'm not sure what in my wheelhouse means. I appear to have read this. I suggested some edits. As I would have approached this document, my assumption would have been, I'm looking at it from my earlier concerns, the policy level concerns. Does it capture the we're deferring to the state? Going back to the put in the petite policy versus not, does it capture the policy concerns of appropriately understanding that we can't force the state to do something? And does it capture the essential elements of the terms that we look for, the imprisonment, registration, and restitution? Alright, so one of the things that is a little striking that's different from the original draft's MPA, even as amended by you. So let's pull out the 16b. Is what I would call the non-admission of guilty. So in the first page of 16b, the first paragraph, that's the first clause, after the 1 through 5 statutes listing in 16b reads, it appears that Epstein has accepted responsibility for his behavior by his signature on this agreement. I'm sorry, you're on 16b? 16b. Okay. It appearing, yes. Okay, so his is, and this is not, this seems to be fairly typical sort of plea agreement language, right? Yeah. And if you look at the top of the final MPA, 22, the third, it appearing clause, fine. Where are you? 16b, right. Has the third, it appearing he has the, down at the bottom, yeah. It says, refers to it has accepted responsibility. Second up, yes. Exactly, he's accepted responsibility. Right. And then above in the fourth, it appearing, yeah. It references the fact that it appearing Epstein has committed offences against the United States. Yes. Okay, so there's a sense of acceptance of responsibility. In the final MPA, which is 22 in your right hand, the third, it appearing clause says nothing about Epstein committing offences. It simply references the US Attorney's Office and the FBI having conducted their own investigation into Epstein's background and any offences that may have been committed by Epstein, including, the enumerated statutes. And then following the enumerated federal statutes, there's no reference at all to the Epstein accepting responsibility. Do you view that, the removal of that acceptance of responsibility, to be something that was appropriate? So, trying to reconstruct, the focus was on, and I know I'm repeating myself, but jail time, registration, restitution. Whether he accepted responsibility for a federal or for a state, I think my focus would have been on these were the terms. Does this encompass those terms? So, as that concession is not something material as far as... I don't want to use the legal term material, but it wasn't important. So to your objectives. So, is that right? First, I'm not sure.
So it wasn't a concession from those 4 bullets, right? It was a concession from an earlier draft, right? And so to say it's not important is, again, there was an early draft. It changed. The focus was in any give and take. Drafts change. The focus was, did he go to jail? Did he have to register? Did we have restitution? Alright. I'm just checking on my cats. One of them is downstairs because I can hear my hob going off. Not to say the hob is on. It's just when it detects something on the keypad, it tends to make a beep. So Dexter's unharmed, but he is the one being where he shouldn't be. And Clara is fast asleep in the corner of the study, right there. Yeah. Did tuck them out earlier when I played with them, so yeah, definitely got to do that more often before a stream. Anyway, carrying on. By redacted. Do you remember noticing that change and thinking it just doesn't matter? I don't. In all candor, until right now I was not aware of that change. I doubt it would have taken 2 documents and sort of put them side by side, as opposed to, does this capture what we're trying to get to? By redacted. So does that... I was aware of the 24 to 18. But up until this question, I wasn't aware of that change to my recollection. So, by redacted. And you're aware of the 24 to 18 because you noticed it in the MPA, or because somebody told you separately? Or do you know... I can't say other than I was aware. By redacted. In the final MPA on page 5, there was a series of things that are included at the bottom of that page, in that long paragraph, and the one that I want to focus on is the immunity portion. That was certainly not in the original draft proposed by the US Attorney's Office. In this paragraph, the United States agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to heavy redaction. Did you notice that provision? I don't recall focusing on the co-conspirator provision. To the extent I reviewed this co-conspirator provision, I can speculate that my thinking would have been the focus is on Epstein's. Epstein's going to jail. Whether some of his employees go to jail or other lesser involved is not the focus of this. Alright. This particular provision, as you know, it has enormously generated, criticized, enormous, yes, for a number of reasons. One of which is that it is blanket transactional immunity. It gives blanket immunity to unnamed, unidentified, yes, potential co-conspirators. People who, even in the future, if evidence is developed against them, as long as they could be considered co-conspirators of Epstein in this conduct, they have a get-out-of-jail-free card. Do you have any idea where that came from? I don't, and I don't want to characterize it as giving... I understand how it could be read that way in the record. I don't want to characterize it, but I don't know where this could have come from. I would review this for the policy concerns. Did it do the sort of the bullet points of my assumption, rightly or wrongly? Would have been that redacted and redacted would have looked at this, and that this was appropriate? I understand your point. Alright, and I believe the point you were referring to is that when I use the term jail, get out of jail free card, that you recognize this is limited to your district. And that's an important point, of course, to recognize. Of course, but nonetheless, this does give blanket immunity to people if you have no idea who they might be, correct? If you had focused on it, would that have raised some question in your mind? If there was a discussion like what we're having here, then it very possibly could have raised. It's difficult to say it would have, but I understand your concern. Alright. And the named individuals, massive redaction, are all individuals who are described in the Pross memo and so on. And the Pross memo does identify that at least one of these women, herself, engaged in sexual activity with minor girls. Yeah. So that she has liability in and of her own. So I don't have an independent recollection of that, but when I reviewed the Pross memo, I did notice that. Alright. Now, you told us this morning that you have no recollection of that actually having read the Pross memo back at that time. I think what I said was I don't have a recollection of whether I did or did not read the Pross memo. I have since, when you've provided it, read it, and I note that it does reference her. Having read it now, does that change your view of anything that we've talked about so far today? So, reading it 12 years later, knowing all of this, possibly. And part of it is, I do not think we approach these cases differently, and I think these cases will play out very differently in court today. I think it's very different to sort of go back and recreate a thought process from 12 years ago. Dex, don't get in the way. And if you were relaying back then on the characterization and summary and recounting of this case to you by your people,
your senior people, redacted. Mm-hmm. And in particular, redacted. Right. Do you have a, did anyone, Dex, move out the fucking way. Did anyone in that ground include redacted Laurie in any way to your recollection characterize this case as not serious or as trivial, or as involving unimportant victims? In any way try to diminish either the conduct or the victims? Not my recollection. I do think there was a concern as to how the victims would present in court, given impeachment, and given contradictory statements, but that's different than trivializing the case. Alright, okay. Back to the immunity provision. Were you aware that none of the four named co-conspirators had cooperated? I was not, to my recollection. Do you recall any other case in which blanket immunity in the U.S. Attorney's Office, in which blanket immunity virtually without limitation, I was granted? I don't recall discussion around this provision, and a general matter, I did not discuss in typical cases that bubbled up to my level, the focus was on who the prime, target is, and not on what we would do with the co-conspirators. And so, I don't recall, but that doesn't mean it didn't happen. And that's just not typically something that I got involved with. And likewise, immunity being given to non-cooperating co-conspirators, or co-defendants, is that something that was done in your office? Again, as a typical matter, I did not get involved with these, but let me also say that this wasn't a federal prosecution in the first place, and so this whole thing is Swiss generis to some extent. It is, but the grant of immunity is real, right? I understand where you're coming from. All right. If you had focused on that provision, would you have insisted it come out? One question I would have had is, if we're naming, as I sit here in sort of focus as we are now, but this is with the benefit of hindsight and criticism. Mm-hmm. If there are specific folks, why do we have any potential language? Because that seems quite broad. It's without limitation as to people as long as they're co-conspirators, right? And so what is the need for that? Okay. And I see. And so, if we had this kind of discussion, I would be sending redacted an email saying, what's the need for this? What's up? But to be clear, as we sit here today, you have no recollection of having noticed that. I don't have a recollection of... If I read over it, my assumption would have been that redacted and redacted thought this through and sort of addressed it for a reason. Alright, and if... By redacted. And did you have anyone ever come to you with the evidentiary issues and say, we need to track this down before we give such a blanket immunity? I don't recall any conversation around co-conspirators. By redacted. This is where there is a mention of computer equipment. There is a provision later in that same paragraph that provides that the federal grand jury investigation will be suspended and all pending federal grand jury subpoenas will be held in abeyance unless and until the defendant, violates any term of this agreement. The defendant likewise agrees to withdraw his pending motion to intervene and quash certain grand jury subpoenas. Both parties agree to maintain their evidence, specifically evidence requested by or directly related to the grand jury subpoenas that have been issued, and including certain computer equipment, inviolate until all of the terms of the agreement have been satisfied. Do you view that this agreement to suspect at least certain aspects of the federal investigation to have been an appropriate concession? Again, my focus was on certain points. I would have assumed reading this that this was thought through. Okay, and that people had thought it through. Alright, okay. There is what's being criticized as a confidentiality provision. Yes. Right. Oh, God damn. My arse is numb. Right. And that's on the same page 5, paragraph 13, which provides that the parties anticipate that this agreement will not be made a part of any public record, and then there is an exception for FOIA, or compulsory proceeds from a court, in which the government will provide notice to Epstein. That seems to be limited to the placing of this document on the public record, right? As opposed to sharing it, or disclosing it for whatever purpose to individuals. Is that a distinction that makes sense? That is a fair distinction upon reading this. I'm not sure that is a distinction that was... I'm basing that on my reading currently, and not as a recollection. And in fact, the parties, both defense counsel and even the U.S. Attorney's Office, took the position that this should never have seen the light of day, even to be disclosed to, victims or other parties in interest, except for filling it. Or except for sharing it on a limited basis with law enforcement. I think there were emails that talk about it if we share it. We'll tell them not to disclose it. Mm-hmm. Is that sort of overstating what this paragraph requires? Possibly. We can get into that, and we can discuss it. I will need to understand a little bit more.
I know there was litigation around disclosure on this, but I need to understand much more the positions that we took and the why before committing on them. In Exhibit 23, there is a discussion of whether the MPA after it has been signed could be revealed. The existence of it could be revealed to the police chief, or even the FBI, or the girls, and redacted in the middle of page 1, or 2/3 of the way down on page 1 of Exhibit 23, proposes that if we tell anybody about the MPA, you just ask that the recipient of that information not disclose it. And you then, at the top of the page, to Laurie and Redacted, who is going to take over Redacted Laurie's position as the managing author in West Palm Beach, should talk with you about it on Wednesday, You should talk about who we tell and how much. Do you remember that conversation? And I don't. I know there were several concerns about leaks in media, and I imagine that we had a conversation quite literally about who to tell and how much. And did you feel that this, at the time, as best as you recall, did you feel that that clause bound you to not tell anyone? So my recollection of the clause, whether it was this clause or whether there was a discussion, I was aware of this provision, and my recollection of this provision is at some point it was raised as something that was the subject of negotiation. Okay. That the office policy was that these types of deferred prosecution agreement is not made part of the public record, and therefore that this is not a substantial concession. Because of the typical course of business, that would not be part of the public record. And that's because it's a non-prosecution agreement as opposed to a deferred prosecution agreement. So, deferred prosecution is not to analogize from a non-prosecution to a deferred prosecution. These are, if the non-prosecution is not typically part of the public record, the deferred prosecution, it makes sense that it follows the same. And so, it seemed a concession. I understand how it was perceived publicly after the fact. At the time, it seemed that we weren't giving up much, because the typical policy is this is not part of the public record, and individuals need to file a FOIA. And so by saying it's not part of the public record and individuals need to follow FOIA, if that is viewed as a concession, it really isn't. So is it understandable that Epstein would not want this document to see the light of day because it describes the existence and nature and scope of the federal investigation? Right. And also his concession to liability under 22.55. It's understandable. It was also my impression at the time that it would see the light of day because, if victims have 22.55, the ability to get 22.55, they obviously have to hear about it from somewhere. And given the press interest, eventually this would be FOIA'd. And so from my thinking at the time, rightly or wrongly, this is a concession that's basically saying we'll follow office policy. And we're likely going to be FOIA'd on this anyhow, and it can play out in the FOIA. And so, is this really a, concession? Alright, another piece of the agreement is something that is absent, and that's the sort of typical language that you find in pretty much any federal plea agreement, which is this agreement only. The defendant understands that this agreement only binds the U.S. Attorney's Office for whatever district he or she is in, or, right, and that truly what you would call global dispositions are unusual, right, for the federal government. And I would note, and this is after the fact that it does say this district agrees. Okay, understood. And it also has you as a party, not the Department of Justice, right. But it does omit that standard language, and do you know whether that was done sort of by mistake or consciously? I can't speak to that. Alright. Another piece is phrasing that you injected when you addressed the first, it was towards the end, right. You talked about injecting the best efforts language. Yes. Okay. Does it? I believe you made clear why you did that. That is, to avoid the appearance of having the federal government be dictating anything, but why rely on best efforts, and to what extent is that even enforceable? So first let me say it was not to avoid the appearance. It was to avoid the actual legal discovery dictating, but so Epstein understands that he has no authority to require that to undertake discussions and to use. So, as I recall, if he did not plead, then there was no agreement. No. I'm sorry. Yes. I don't mean to. It appears in number paragraph. Right. 11. Epstein shall use his best efforts to enter his guilty plea and be sentenced no later than the, set date. And then in the first paragraph after numbered clause 11, he will use his best efforts to ensure compliance with certain procedures and best efforts to convince the judge of the Florida court to accept his binding recommendation. So best efforts kind of became a sticking point in enforcement, didn't it? Because what does it mean? What does best efforts mean? So I think it's fair to say that one of the issues that came up after this was the US Attorney's Office, at least from my perspective, was in a little bit of a bind because we had agreed to this, yet he wasn't turning himself in. And so how do we deal with that? And so there's not a phrase that I focused on at the time. I understand your point. Alright, I'm going to move on from those. Is there anything else on those MPA clauses? And finally, let me just say you didn't ask. We had incredibly experienced attorneys in the office. I assumed, rightly or wrongly, that this language had been thought through and vetted. And, sitting here 12 years later, I understand the issues that have arisen from it, but at the time, these were not issues that were focused on. To your knowledge, who was involved in the drafting other than Redacted on your side? Right. And Redacted Laurie, and you to some extent? So I can't say 12 years after the fact, but again, Redacted Laurie, very experienced head of the Palm Beach office, have prosecuted any number of cases. Again, just to keep, perspective and context, the final week that this was being negotiated, Redacted Laurie was in Washington and bouncing back and forth on the weekends because he was in transition to the front office here in the criminal division in this building. That's a factor in terms of being able to give attention to some details. Would you agree with that? It could be a factor. So it could be a factor. On the other hand, I'd say that Redacted wasn't leaving the department. He is professional. He knows his stuff, and you would expect a professional, if they're reviewing a document, whether they're on vacation, whether they're looking to move from one part of the department to another, that you would expect them to review it, fulfilling their responsibility to sort of focus in and make sure that it encompasses what it should. And that's not a criticism of Redacted. That's saying that might be a factor. That doesn't lessen from my perspective reliance on his expertise. Understood. After the MPA was signed, and Redacted came back. Yeah. Right about that same time, he quite quickly identified a potential problem, and that was the commitment the agreement that the US Attorney's Office would identify the representative for the victim. Do you recall him raising that? I don't recall him raising that as an issue, but I know it was an issue. Okay, and that's where I plan to stop. Woo! I mean, I still have the energy to do it. It's just my throat. I don't want to kill my throat, and I will admit, I did pour myself a whiskey. Haven't had any of it since I started, and I would very much like to. So, to clarify, we did about 170 pages. Just doing that. It is 2 hours and 42 minutes just now. I think that was very, very good. It's much smoother, much less painful than the last one, and hopefully I can continue. I can continue ideally tomorrow. I can get this bit finished, and then by the weekend I can sort of compile it all up, splash it up, and release it as a separate VOD. But yeah, I need a little bit of a break. Chug a bottle of honey. I am on the keto diet at the moment, so I can't have any carbs whatsoever. Well, I can have some carbs. I'm allowed no more than 20 grams of carbs a day. Unfortunately, honey has carbs. But, the result is I've got the energy and I'm getting thinner. And I need to get thinner. I'm a little bit too chubby. But yeah, whiskey is a good way to numb the throat as well, so that's why I've done this. And whiskey, a spirit I can have on the keto diet, so that's always good. But yeah, I'll just do that. And okay, we're making good time. 20 to 11. Chug a bottle of bees. Possibly. But regardless, I'm just going to have a look at the chat before we go, because I'm very sorry, everybody, but I didn't address the chat while I was doing it. So I will address the chat now. I think the lack of distraction has helped me, but it's very rude to you guys, so I very much appreciate it. For what it's worth, thanks for doing all this by Loitivert2780. Yeah, no worries. I'm happy to do it. I'm doing this for charity, and I very much identify with the cause of the victims. So as I say, I don't care who's guilty. I don't care what side of politics or whatever. If they're guilty, drag them out. The only side I'm on is the side of the victims. And, the public who wants to know. Hey, nice to see you keep this going. Yep, absolutely happy to do it. Hello, Aaron, you're back here. Okay, but where is the rebel base? No pressure, mate. I'm assuming that is in reference to something I said earlier. Just happy to see somebody give those files the attention they deserve. Yep, absolutely. And I think when I eventually put the VOD up with this whole interview, it's going to be 6 to 7 hours long. Probably closer to 7 hours long. So that's going to be fun. I understand. Oh no. Oh, you're talking about the pets as well. Our pet set off the Roomba today. Oh yeah, my two did that when they were kittens. The Roomba doesn't work at the moment. They set it off when they were very, very young, and they have not approached it since. But my Roomba did break because it went over one of their shits. And I've tried to clean it out. Still won't work, so I suspect I'm just going to get it replaced. I'm probably going to get it replaced with something much better. Because my current Roomba I bought like years and years and years ago when I was in London. And it was the cheapest model I could find at the time. And as at London, I wasn't making a decent amount of money. So, it's lasted a decent while. And I'm not complaining. But yeah. They're afraid of the living room now. No, I think the moment I let my cats into the rest of the house, the living room was the first place they went to, and they kept hiding under the sofas. But now their favourite place is definitely my study. Or unless it's sleeping at night, in which case they always come up onto the bed to come see me, and I love that. They will come around eventually. I mean, and Dexter especially, he's massively turned things around. He's so affectionate. I mean, Clara is as well, but Clara, she keeps poking her nose into places that she doesn't need to go to, and I need to sort of dissuade her from going there as well. Whew. So yeah, I think I'm going to have some water, I'm going to have some whiskey, and I'm going to try and go to bed as soon as possible once I finish the whiskey, but I'm just going to do some light reading without the talking. And hopefully I'm able to carry this on tomorrow and get this one finished. But yeah, thank you everybody for showing, and yeah, I mean, if you can spread the word around that I'm live narrating the entire Epstein Files as well, that'll be great. It would be great to get some more people in the chat, like sort of like a mission support if I can't read something, or if if I need clarification on something. That's dead useful to have. So yeah, but anyways, I've been talking too much. I've talked enough. I need to give my throat a rest. Ladies and gentlemen, it's been a genuine pleasure once again. Yeah, I'm still going. Dataset 7, I'm still going, and it's possibly not next stream, but the stream after, I will be finished with dataset 7 out of 12 datasets altogether. I've been telling everybody on my Discord, thank you very much. I very much appreciate that. As I say, it's normally bad form to tell people to, spread the word, get people coming to my channel, but I think in the case of the Epstein stuff, it's not the normal HFI content I do. It's not normally a draw, but I know for a fact there's going to be a lot of people out there who are interested in me narrating the whole thing. But anyway, good night, everybody.